since long, Your Lordship. So 2023 matters.
20?
23.
23 will not come.
But convicted under
Huh?
23.
23, I don't think it will come. Just check.
My Lord,
If it comes, then
there is a noting, Your Lordship. If the appellant is in judicial custody in a heinous crime,
verify the registry. Huh?
Well, great.
In that category, it may come.
My Lord.
Yes.
Any mention from item number 1 to 6?
Yes.
7 to 13?
13, Your Lordship, yesterday only I got the LCR. My Lord may
13th?
Yes.
Yes.
So my Lord may fix it on Thursday. Coming Thursday.
Okay. Oh, this is a parted matter which you argue.
No, Your Lordship. This is another matter where I'm an amicus curiae.
Item 14 to 23?
Item 15.
Yes, 15. What do you want, madam?
26.
Sorry?
On behalf of Satyavit Mahanti.
Sorry?
On behalf of Satyavit Mahanti, 15 and 26.
What do you want here?
Next to
96 matter. You are appearing for the
on Satyavit Mahanti.
amicus query. What do you want?
Next to it, my lord.
Amicus query shouldn't ask for adjournment.
My lord, my senior on is
The routine counsels are asking you for adjournment, therefore I am appointing amicus query. If you ask, then what
due
do
to
you
death of his cousin, my lord.
keep it? Huh? Okay. 15 and 26. Keep it. Yes.
24 to 33?
I may pardon, my lord.
Yes.
Item 29. Lordship, since it is my father's Shraddha today, I'm not able to attend court in physical. Lordship, may it is on Thursday or Tuesday next?
29, huh?
My lord.
Okay. Well, next Tuesday. Yes. Yes.
Oblast.
24 to 41?
Lordship 39, it's a vigilance matter, Your Lordship. Your Lordship, I'm doing one matter today, so let that come on next Thursday. I've taken.
You decided to do one matter a day.
No, Your Lordship. Thursday.
Okay, list it. Yes. Yes.
52 to 51? 52 to 65?
My lord, item 61 and 63 on behalf of Mr. P.K. Padhi, my lord. 2 weeks after, my lord, I will verify same type of matter although disposed, my lord. I will verify then. Item 61 and 63, my lord.
What do you want to verify?
My lord, similar type of case already disposed, my lord. So I verify this case is disposed or not, then I will argue this matter on behalf of
Day after
Mr.
tomorrow? Day after tomorrow. Verify and tell me.
Or 2 weeks after, my lord.
63 item 67.
My lord, 2 weeks after, my lord.
No, not 2 weeks. Because see, this he is very old. I have to get
My lord,
him
only take it, my 1 week, my lord.
report I will have to get because he is 67 years of age.
My
So I'm putting it at Thursday. Get a whatever you want to say, tell that day.
My-
Yes, next.
my lord. 61 and 63, my lord.
61 and 60?
3, my lord.
Okay. Okay.
This will please your lordships. Item number 64, my lord. I'm appearing on VC, my lord.
Yes.
My lord, it's an old matter. I'm not able to fetch the file, and also I do not have the instructions, so it may come after 2 weeks after, so that I'll just figure out.
See, your clients are very old. 60.
I understand, my lord, but I do not have any instruction.
I'll get a report in this case. Get a report. Huh? Get a report.
My lord.
The report released. The report. 19. Okay. 19. Yes. 19
of
August.
August, my lord.
Yes.
My lord. Obliged.
Yes. Yes, 58.
Paper is not prepared.
Paper will never be prepared. You have to get ready.
Because file at all. Because
That's it. You can
less
Age of children, 2 months to be supposed to.
What are the offenses, sir?
I don't know because file has not discussed somewhere.
The
Year of 2010.
Yes. So Subhalakshmi,
So I'm just-
what is the offense?
Item 58.
The sentence is only 2 months. No, 1 year. 1 year with fine of rupees 1,000. Okay. Learned counsel for the 58, huh? Item 58,
Yes,
you're
ma'am.
talking about. This is Tapan Kumar Chaudhary.
Yes, Tapan Kumar Chaudhary.
Okay. Learned counsel for the appellant submits that he will reconstruct the file and argue the matter on the next set of hearing. Yeah. Let him obtain the soft copy of the file
Sets
from
up.
the registry and soft copy. Take soft copy of it.
66 to 82.
Please understand.
69.
I'll
A
just-
file has been misplaced and I will obtain TCR. But one of them is 63 years.
One of the, who is 63?
Third appellant is 63.
63 is all right. What about? What is the offenses? And here nothing is visible, nothing, not a single line is visible.
324.
Ask any of them. Just see. 69 just.
324, 34 I think.
1 minute. Will be not just see. No, but see what, who has done it? This blank papers. Even if I ask her to take soft copy, she can't take it. Because the scanning is completely blank. Even if I'll ask you to take soft copy, you can't get anything. Just see the record. Impy not just see, completely blank.
Legible.
I'll be holding it.
You have to take hard copy from the registry somehow, apply for certified copy or something. You see, you don't certify and list it up. 3 weeks, yes.
Whereabouts will
Sir, item 54, sir.
Lord, whereabouts will be confirmed.
Whereabout you have to find out. Only if the senior citizen I can get it. Yes.
One is 63 out of.
Well, I'll see it. The record is not, you can't read it out. Yes.
Sir, item 54 may taken up for 1 week after because same problem, the file is also not pressed out.
No, Mr. Ponda is asking for time. What is this?
54, 60 of 2007.
Mr. Ponda appears for the appellant. It's all. Okay. Yes, start.
Sir, Hon'Ble.
Item 1.
Wait, please, Your Lordship. Item 1, my lord, paragraph number 11 and 12 need modification, my lord.
Which one? Order dated?
Order dated, Your Lordship. The judgment dated is 4th March 2025.
Yes. Which paragraph?
Paragraph number 11 first, my lord. Concerned to the IA number 1736 of 2025.
11.
My lord, what Your Lordship observed, this court is alive to the fact that a young life has been lost and no amount of compensation would compensate for the loss of the child. At that time of hearing, Your Lordship, the government counsel said no compensation amount paid to the family of the deceased. But I get the RTI details.
What do you want to change?
My lord, I get the RTI details from where it's clearly visible, my lord. The government already paid 4 lakh rupees as a ex gratia amount.
Government paid, but you have not paid.
But my lord, I am not the guilty in this matter also, my lord. No prima facie case is made out against
I can
me.
only reverse the judgment.
Your Lordship.
I know what kind of thing you have done.
I have-
Therefore, you say that I am ready to pay the.
I am ready to pay because
Pay
no
1
one
lakh
paid,
rupees.
my lord, that time.
As simple as that.
No one paid at that time. What they said, aji portion to diya hai,
I distinctly remember, forget about who has paid what.
my lord.
Distinctly remember when you argued the matter, you said that, okay, I will.
I am ready to pay, my
1
lord.
lakh.
That's why I am
You
concerned.
pay it. As simple as that. Why? What is
Paragraph
the,
11.
When they paid, the government already paid 4 lakh rupees,
No,
my
you
lord.
have to. Otherwise, I will not pass it.
50
It's not a case for quashing.
Paragraph 11, Your Lordship has reflected that he has agreed to pay
Yes,
this.
agreed. Yeah.
I am agreed because
And
they
the-
hide the
the-
things, Your Lordship.
Application for modification is misconceived.
50% amount.
Hence, the same is rejected. Yes,
And next IA is there, Your Lordship. Next
Yes.
IA for modification of para number 12.
12, yes.
My Lord, in this para, Your Lordship observed, initiate departmental proceeding if not initiated, and
Can I stop it? In a 482 proceeding, can I stop that departmental proceeding shall also not be done?
observation.
I can't do that.
But
Because
in that
I
paragraph,
was exercising 482 and you are a teacher. What have you done?
I have not
Whatever.
done anything. I'm a
Because there is
NCC.
no material. There was no material. You have given punishment to the boy as a result
It
of
is the afterthought of the father of the
whatever these
deceased.
are. Then you face the trial. I'll
No,
recall it.
but in para 12, Your Lordship not mentioned that proceeding is quashed.
Can I, even if I'll remove it, that is neither here nor there, because department has its own way of doing it.
Yes.
482,
But-
482, this
But
is,
in para 12 or 13, nowhere mentioned, my Lord, the proceeding is quashed.
proceeding I have quashed.
No, my Lord. In the para 12 and 13, nowhere mentioned.
That no case is made.
No case is made out, but how?
No, I'm just helping you. I'm
Yes,
helping
yes.
you. I understand the anxiety from that side, but Lordship has depicted that as there is no material level.
I have said that the observation made is in the judgment will not.
But,
include
my Lord,
the
Your
document.
Lordship, in a broader sense, Your Lordship passed this order, but the learned magistrates are very.
Make them broad by reading it. properly.
I am not the authority. Your Lordship.
See, I gave indulgence in 482, quashed it, thinking that it is an ordeal for both the family and you. Otherwise, this is not a case for giving indulgence.
Well, but, my Lord,
Right on. Okay. Right on. The second IA.
No, first IA, that is 1735. That is the first IA.
Okay. 1735. 1735.
भूल रहे थे एयरपोर्ट से पड़ी थी
1735 लिखो. In this
para 12
application, the petitioner is seeking modification of para 12 to the effect that the observation made by this court regarding the departmental proceeding be waived, be expunged. Mr. Staff and Counsel for the petitioner submits that this observation, for the observation made in paragraph 12, the department, even if the department was not initiating the proceeding, they construe as if this court has directed the department to initiate the proceeding. Therefore, he seeks a clarification. Regarding head to the reasoning given in the application, the same is allowed, and it is made clear that while allowing the criminal MC filed by the petitioner, the criminal prosecutions has been quashed. However, the observation made by this court for leaving it open for the department to proceed against the petitioner departmentally is not to be construed as a direction by this court.
Grateful, Your Lordship. Highly obliged.
Yes.
The other IA to be dismissed.
Dismissed.
All that is
I will pay 1 lakh.
the other IA is this. Yes. Yes.
Item 2, my lord, next matter.
1 lakh is heavy, my Lord. 1 lakh.
1 lakh, I'll increase it for these frivolous applications you move.
My Lord, that 4
So
lakh.
don't waste time. Don't waste time. I may change mind very frequently. Yes.
Sought for a modification of my lordship's order passed on 29/12/2024. Only date of surrender may kindly be extended.
For the reasons stated in the application, the application is allowed. The petitioner is allowed to surrender, appear before the court below on or before 15th of August. It made clear that no further extensions are needed. Yes.
Obliged, sir. Item 3,
Yes, my lord. Modification for order dated 3/12/2024. Extension for time for surrender.
See, I have already extended once, sir.
Yes, my lord. But
And I have indicated that there shall be no further extension.
yes, my lord. But due to severe illness, the petitioner.
What have you filed? For
I
illness?
have filed a medical certificate.
Where is that?
That is annexed 4, my lord.
4 to?
4, page 14.
What has happened to you?
That is, my lord, he is suffering from severe breathing problem and chest pain, sir.
Oh, these are private.
Yes,
Shall I
sir.
call this doctor? He will tell the truth. I know what kind of prescriptions are being obtained. NBW was issued. I give indulgence. I gave you time to surrender. You didn't surrender.
Yes,
Moved
sir.
an application for extension. I gave an extension, making it very clear that no further extension shall be given. Now you obtain some medical prescription from a private institute. You say that like that.
For the last chance. my lord.
How much you have paid to obtain this certificate? The same amount you have to give it to bar. You might have paid something to the doctor.
Yes, my lord.
Otherwise, doctor will not write like this. A private doctor can write anything. So how much you paid? You say same amount you pay to bar. I'll extend.
I have already deposited 500 earlier, my lord.
1,000 you deposit, right?
Oh, my lord.
By the order dated 3/12/2024, the petitioner was directed to appear before the court below on or before 25/12/2024. Instead of appearing and surrendering before the court, the petitioner moved an application for extension of time. The said application was allowed by the 16/5/2025, extending the time for surrendering up till 8/5/2000. When up till 23/6/2025. And it was made clear that no further extensions shall be granted. However, the applicant has moved, repeated the similar application, similar application, making the same prayer. The counsel for the petitioner is relying upon the medical document annexed with the application and submits that the petitioner is not well, and therefore he could not surrender. The application is also filed belatedly. Be that as it may, the last and final opportunity, the time to surrender or appear before the court below is extended up till 15th of August 2025. 25. The petitioner shall also liable to pay a cost of rupees 1,000 to the High Court Bar Association. High Court Bar Association, subject to payment of cost and clarification that this is the last and final opportunity to surrender. The application is allowed. Yes.
Mobilization.
Item 4. May I please address? Pray for modification of order date 2012 December 2024, my lord. The certified copy supplied by the landlord court below. GR case has been mentioned instead of city case, my lord. GR case 30/12/2019.
Case number is different, huh?
Different.
Correct the case number. Okay.
I have filed a certified copy also.
It's all right. Certificate copy is there. As flag B, accordingly you change it. Okay. Yes.
Item 5. May kindly extension of time may be extended.
No extension because of the aforementioned confusion. Yes.
Obliged.
Yes.
May I please ask you? My lord, petitioner has filed an introductory application for modification of the order dated 15 January 2025.
14 January is it's item 5.
Madam,
Yes.
extension of time, my lord, for surrender.
They are supposed to appear when? What was the time granted to you?
By time granted, my lord, by 30th January.
30th January.
2025.
Okay, for the reasons stated in the application, the time for the time is extended to surrender also up to 15th. It made clear that no further extensions are needed.
Item 6.
Yes. 15th August, no further extension.
My
Yes.
please, Lordship.
Six.
I is for extension of time to surrender, my lord. Your Lordship directed to surrender on 19/3/2025, my lord.
First order? No further-
19/3/2025.
Okay. 15. Last and final opportunity.
Obliged.
Yes.
Item 7.
This case, my last reason, Lordship issue notice.
But service is not complete.
Well, he has received notice. Lordship can the noting well, he has received the notice.
Item deliver.
Well,
It shows neither any AD nor undelivered notice received from the
but
petition till now.
item is delivered.
Item delivered.
The service देखो. What kind of modification you are seeking?
This is a case, my lord, the Domestic Violence Act, my lord. The interim order was passed by the London Magistrate, my lord. Again, thereafter, he did not pay that amount. Area amount is more than 6 lakhs, my lord. Since the petitioner did not pay the amount, my lord, the London Magistrate issued no NBW. Challenging that NBW, the petitioner came before this Honorable Court, and this Honorable Court, without issuing notice, though the petitioner, the wife is a party, my lord, here, my lord, without issuing notice, the Lordship disposed of the matter, and he has gone prison bail, my lord. I am not able to get any amount, my lord. That is, that is more than 6 lakhs.
This application is moved by the wife.
For the
Moved by the
record.
wife. This is the present application moved by the wife.
They have a remedy
I-
available for execution of the
No,
compensation.
now
regular-
if now he is not appearing, then NBW will be issued.
Further,
NBW
the magistrate is not issuing any further NBW. Since the Honorable High Court has granted bail, my lord, then he is not, for that reason, I have filed this application.
Where is the proceeding of the magistrate? I have not said only the for
Your
particular case.
Lordship, only
NBW
direct.
was issued. I just
NBW was issued.
NBW
Against that
has
order, he has
nothing to do with
approved this Honorable Court,
compensation amount.
and this Honorable Court directed to religion bail without expression on your opinion.
where have you said religion bail?
My lord, that is the Lordship can the order, my lord.
Where is
The order
it?
of this Honorable Court, my lord.
Show me.
The order of this Honorable Court, Lordship can the order dated 28/3/2024.
Read it where I have given bail.
Yes, my lord. On the basis of relevant portion, Lordship can
The basis of the aforementioned fact.
appropriate fact and circumstance of the bar, the order dated past in connection criminal execution number pending the court of justice
Set aside.
set aside
Huh?
and subject to petitioner surrendering before the court on honor before ethic and depositing
Where
500
have you
rupees.
given the bail?
My lord,
Where I have given the bail?
that means he has religion bail, my lord.
Where?
Bishop,
How?
may I?
That he has,
NBW is issued for a particular date.
Well-
I have set aside it
Well-
subject to condition that he go and
Well-
appear.
my lord.
He might have appeared and the process will
He has,
be
he has
issued
appeared and he has gone on the basis of order passed by this Honorable Court. He has religion bail, my lord, by the London
May I-
Magistrate, my lord.
Bail is something different, sir. Why don't you
May I
understand that?
submit your lordship?
Huh.
They can use this code for realization of amount since they have a
No,
statutory remedy
you
available for
have a remedy
execution.
for that.
My lord, remedy, my lord, only execution case, the
Let
order has been
the
passed, my lord.
execution case.
On the execution case,
I understand. In execution case, NBW was issued
my lord,
to the husband.
my lord,
He came here.
my lord,
I quashed it saying that go and appear on such and such day.
and deposit 500 rupees.
And cost is 500. Then routine
well-
I passed that order and I said that go and surrender and resort to the remedy.
I get.
He might have surrendered.
Surrender and religion bail. By the
Obviously,
London
the
Magistrate, my lord.
execution petition bail will be granted. What is the
No,
great deal
even
about
if it
it?
is
That
recalled,
the regime, my lord,
Put to
here.
trial, put behind the bars. Then how will you get?
No, I am not saying that my
But
husband
this will not
and
remove-
only thing, my lord, since I am a party here, this case, my lord,
Okay,
I have not
I'll
been issued
clarify.
notice.
I'll clarify.
Only,
I'll clarify. Okay. Right on.
distress lady,
The
lordship.
petitioner, the applicant in the IA number, which IA you are talking about?
My lord, I have
1589.
1589 number 24.
1589. 1589 application. The applicant is the wife of the petitioner in the in CRLMC. CRLMC number 1250 of 2025. She was although impleaded as opposite party number 2 in the CRLMC. However, the CRLMC was allowed by the order dated 2/3/2025 without issuing her notice. By the order dated 28/3/2025, this court, while setting aside the NBW issued by the JMFC 14 Bhubaneswar, dated 28/10/2024, directed the petitioner to surrender or oblique appear before the court below on or before 30th of April 2025 and avail the remedy under law. Subsequent thereto, the appellant, subsequent thereto, the petitioner has appeared before the court and he has been released on bail. Learned counsel for the applicant submits that but for the order dated 28/3/2025, the petitioner is subsequently not appearing for the trial court, appearing for the trial court where the execution petition has been filed by the applicant. That's the result. The applicant wife is not getting any maintenance amount. Therefore, he seeks indulgence of this court to recall the order dated 23/2025. I'm not inclined to entertain this application because by the order dated 28/3/2025, only this court has set aside the NBW order and directed the petitioner to appear before the court below, which he has complied with and appeared. It is open for the applicant to move appropriate application before the trial court to issue appropriate process against the present petition if he doesn't appear in the execution proceeding. The order dated 28/3/2025 shall not stand in the way of the trial court for issuing appropriate process, appropriate process.
Item 8.
Your Lordship, on behalf of Sri S.K. Mahanti, order dated 5th of April 2025, IA has been filed and extension to
allowed. Yes.
Item 9.
May I please?
Yes.
Final modification of my notes.
Number 9, Your Lordship has called for a report from the regarding the antecedent. While considering bail, the submission of the petition that he is involved in 7 cases. Now it is on record that he is involved in 15 cases in different PS cases.
15 cases.
My lord, I have given those order copy where the coordinate bench has already granted him.
Which case? The
Those rest of the cases.
15 cases she says now.
Yes, initially 7 cases were lost. Later on, 8 more investors came before different.
And the
police
service
stations.
let them file a comprehensive action.
Different police station.
You file a comprehensive petition. In which case you have got bail?
Given the order copy, I have filed an
Right. Pursuant to the order dated 15/7/2025, Sulakshmi and counsel for the state has handed over the written instruction given by IIC Sector 15 PS Raulkela, which is taken on record. Letter counsel for the petitioner is directed to file an affidavit stating in which cases he is already in large along with the application, along with the order of the yes, 3-4 weeks later. Yes, next.
Item 10.
Item 10 has been fixed to 2 o'clock. Item 10 has been.
Yes.
Item 11.
Yes, sir.
I have prepared a
Started.
my lords.
Then I file the
Small date check one.
file. Yes,
Sir,
what
we
you
have
say?
total
Date of occurrence, date of logic FIR is by case so. No, what exactly you want to say? That is
The
ordered.
case under 148, it was sentenced for 1 year, 323 and 149 for 6 months.
Yes.
But the allegation is by the PW1, who is the informant here, that they belongs to small party.
Sorry?
They belongs to small party of the same village, same locality, same Sahi, my lord.
Yes.
And the accused persons belong to big party when they went to offer the puja on Dasara day. On that day, he was assaulted.
Yes.
By the appellants. My lord, there are 14.
How many of you are there?
Right now, my lord, 5.
5 of
They were convicted out of 14.
Out of 14.
14.
Yes.
Others were acquitted, my lord. My lord, the FIR story, my lord, says that on that day when he went outside, he saw one.
You belong to small party.
A big party.
Big
The
party.
appellants belongs to big party. My lord, your lordship has asked me to specify the assault and the
Yes.
corroboration with the
Specific injuries, huh?
injuries, my lord.
PW1, Krishnadas.
At page 4.
Babu, appellant 3 gave lathi blow.
Yes.
And Ghottadas gave
Bodakati.
Bodakati. And lathi blow.
It matches with the look, my lord, the portion of the body, but the as it has mentioned, but it is not the same. It is attributed, my lords. A blow by a Bodakati never be a, my lords, a linear aberration.
So many injuries.
My lords, these are the
Exhibit 3 to 9 are injury reports. Exhibit 3 to 9 are the injury reports.
My lords, and my other injured.
Babu Das lathi blow. That you are holding lathi is confirmed. Ghotto again Bodakati. And
Bhima was holding a stick.
Bhimo on
Lathi
body. And the Gambor assaulted.
PW 2 and 4 is never reliable, my lords, because they have not stated this before the IO, my lord, which is at the IO at Para.
PW 2 and 1 and 2, both of them have said Babu, Ghotto and Bhimo. They were carrying lathi, Bodakati and body.
My lords.
That
My lord,
part
but
is
PW 2 has never said this before the IO. In the examination, he has developed his story.
1 and 2 are injured.
They say 2 and 4 are not reliable since they have not stated so before the police. Assuming for that for a second, even PW 1 and 3 categories categorize the role played by the appellants.
My lords, kindly see the FIR to that effect, my lords. When the informant went to the police station to lodge the oral FIR, my lord, he never said about the assault to other accused persons. He only said that they have assaulted me. Even his son is there who was examined.
How get out of 1 and 2?
2 is, my lords, he has developed the story.
1 and 2 and 6.
6, my lords, these 6 doctor.
3
also.
1, 2, 3, 4 and 6.
3 also, the Babu, appellant 3, there, so, gave lathi blow.
2 has developed his story, 2 and 4.
3 says only lathi blow, whereas Ghotto was holding, according to 1 and 2, Ghotto was holding a Bodakati.
3 has
and
never.
Bhimo was holding a body. And he says that all of them have given lathi blow.
My lords, 3 has never specified the assault. It is an omnibus statement, my lords.
See, 1 and 2, 3 contradicts 1 and 2, insofar as the arms are concerned. Assaulted by head, by his father by lathi. PW4.
Only in respect of
Babu
they
lathi.
consistent.
Babu lathi consistent. Ghotto kati. Bhimo Hinga.
My lord, the material object, the
what is the sentence?
Weapon. 1 year, my lords, for 147.
How much you undergone, all of you?
My lords, released on the same day, 24. They have arrested, but they released by the.
It is case of conviction.
My lords, out of 5, my lords, 3, my lord, there is a chance, but other 2, my lords, 1, 3, and 4, as per the statement of the.
Ghotto and Bhima, they can't
See,
be.
Babu, Ghotto and Bhimo, no escape. Insofar as the other 2 are concerned, that is Krishnadas and Duryodhan Das.
No, my lords.
They may have a case.
Dayadas and Durjadas.
Dayadas and Durjadas.
Whatever.
My lords, in an alternate.
Daya and Duryodhan.
Appellant number 2 and 5.
2 and 5, huh?
In a
Daya
And Durja.
Duryodhan.
In an alternative, I pray, my lords, if occurrences of the year 1991.
91. What it is?
Presently, they are.
At that time, there were 24, 33, 32,
Presently,
52.
Yes. 54, 62, 66, 57, 54. They may consider, my lord, under PO Act, my lords.
We have to check whether they have antecedent or not. Since there is a group rivalry, they might have some antecedent.
And my lord, more importantly, the witnesses.
Can you make a statement that they don't have any?
No, my lord, I don't have any instruction with regards to that. I don't have any connection.
Because there are two groups.
Well, these witnesses were accused in an murder case on the same day of Sadadas. That is why, my lord, their statements is inimical, my lords.
They are involved. Then obviously they are involved.
My lords.
Obviously
They
are.
themselves admitted that, my lords.
Convicted under which provision? 148.
148,
323.
149.
148, 148. What is the minimum sentence?
Which may extended up to 3 years. For with now. There is no minimum sentence then.
Or fine, both. In both the cases, or fine. Then I'll impose fine. Take it. P23. Here also 323 is or fine. Impose fine.
Obliged.
A2 and 5 acquitted, and A1, 3 and 4 convicted with fine. Yes.
Item 12.
May I please, Your Lordships? Your Lordship, this is a case of conviction under 26(1) of NDPS Act. They were punished for 2 years RI with 2,000 fine, Your Lordship.
Ready?
Yes, Your Lordship.
Huh? Then I'll just run through the list, then I'll hear you. Huh? Huh? I'll just run through. I'll just run through the list, then I'll just wait. Yes.
Item 14.
Just ask Ashok Mohan, sir, waiting letter will make them.
14 Millards. Appellant has been convicted under section 354 IPC. He's been sentenced to undergo RI for 2 years. It's a offense under 354. Originally, he was registered for the commission of offense under 376. But I'll need to see the LCR.
See the pass over.
Pass it over. I'll
Pass over. Yes, we get it. Yes, next call.
Item 16.
Yes, 16.
Item number 16.
No, pass over.
The appellant is dead.
Yes.
So in item number 16, the appellant has died in the meanwhile.
No,
Who died?
16 Millards.
16.
In the year 97, he was 66 years old.
I'm saying
have
he's
died.
dead.
I got it.
He's dead.
Then, pursuant to the order dated, there is no order now. When the matter Ms. Sulakmi place on record the report of issued by the Inspector Excise Sonepur Range inter alia Sonepur Range, which is taken on record. As per the report, the sole appellant Raghunath
Sole appellant.
Raghunath Sabat has expired since 2006. Regarding head to the report placed on record, the appeal cancelled. 30? Item?
33.
What? Please come.
Item 30.
Oh, there's one. 33.
Initially, that's it was under 498A 201, section 4 of the Dowry Prevention Act and 306.
Yes.
He has been acquitted of 306 and 201. And that 498A and section 4 of the Dowry Prevention. One for 3 years conviction, another is 2 years conviction, both to run concurrently.
Yes.
He wanted me to take instruction that whether he is going to go on probationary offenders act.
You get instruction then. I think they are also
He
very.
will go, Lord. I told him that what is your occupation? He told that I only sit in Mukti Mandap and I have some coconut trees in my village.
You can carry on even you can provision. Because they are very old people. They see 51
He
and
was 30 in
31.
the year
Year 1999.
Another one has died.
Dad, two.
Appellant number 2 has died. in-
Two has died. It's only about one.
Two.
Okay. Then seek instruction. Shall I put it Tuesday?
No, I have taken instruction.
I'll
He is
provision.
willing.
Acha. Who has died?
In this
Two has died. Huh?
Appellant number 2.
What is the difference between the cause list?
Cause list.
So for the appeal for the opposite party, so for the appeal number 2 has already been awaited by order dated 24 7 April 25. Insofar as the appeal number 1,
Upon the junior as a
the appeal survives. Heard Mr. Ashok Mohanty, learned senior counsel, judgment reason. Okay, PO Act. Huh?
Sorry, the PO Act.
Item 17.
In item number 17, he has called, she has called for a report. Can I seek for one more chance?
No, I have not called for a report. What is the age, by the way?
It's been called, my lords. 4 of them are above 65 years of age.
By order date 3/7/25, your lordship has called for a report.
Appellant number 1, 2,
No,
3,
37, there is no order as such. Anyway, I'll pass.
Probably there is no report.
Right. The call for a report. Huh? Call for report. Call for.
whereabouts and age.
18.
Yes.
18, my lords, may pass it or I'll do it after lunch. 6 months conviction under 3(1)(12) of the SC/STP Act.
Report has come, madam.
Yes, sir. Understand.
Yes, show me. How many appellants? Only one. Sole appellants.
Appellants are
Appellants, no, only one.
Sole appellant.
sole appellant.
This is alive and
Persons to the order dated 3/7/2025. The report dated 20/2025 by DSP Firingia Police Station has been filed, which is taken on record as per the report. The appellant is residing in the village and engaged in the agriculture, engaged in the cultivation, ability ready for hearing. Yes, yes. What do you want to say?
No, I'll do it after lunch. Let's pass it over.
Put it for some other day. The report today on the report.
Okay.
Today on the report. Yes. Yes.
19.
Yes.
18, my lords, sole appellant.
Got any report?
report was never called for in the matter.
No, report was called for by 27/3/2025.
Yes, my lords.
Learned additional counsel shall obtain instruction regarding the whereabouts. What is the age, by the way?
He was then in 1998, he was 29 years.
Around
90,
59.
you are 20.
59.
25.
Get a report. The report pursuant to the order dated 27/3/2025 has not yet been obtained. Subulakshmi seeks an adjournment. Please the matter. Yes. That you are right. You are listing those matters on 19th. 19th. August. Yes.
Item 20.
20. Yes.
I request one more chance to call for that.
Okay. 8/7/2025. Order not complied. Yes.
21.
Yes, madam. 21 also you are there? You are for appellant?
Yes, sir.
Last time you didn't appear. I was about to appoint amicus curiae. Now, tell me.
We'll collect the paperwork, your lordship may fix a short date.
Sorry?
Yeah. We'll collect the paperwork, your lordship may fix a short date for hearing.
You vanish on many hearings. All of a sudden, you once I about to appoint amicus curiae, you came. Now, you say don't have the file. Take the file. Don't so appears for the appellant and submits that she has to reconstruct the file. The appellant counsel for the appellant is permitted to take soft copy of the file. Yes.
22.
52 minutes. The applicant is about 60 years of age. I think report hasn't been called for minutes.
Yes.
He's about 60 years of age minutes.
No,
We have all
no report was called for.
No minutes.
No report was called for. Yes. 60 years.
It was 32 in 1998.
Yes. Don't see the cause title up for the appeal paperwork. Just see the
Judgment.
judgments or the charge sheet. Right age will be reflecting there. What is the name of the appellant?
Name of the appellant.
Muktikanta, your lordship.
Muktikanta.
He was,
He was
accused from
28 years in the year 1998.
He was 32 then.
98 yeah. In fact, 94 must be. You have to see the charge sheet. Charge sheet will give you the right. Ratikanta, I'll just tell you. Ratikanta.
He was born in 1966.
He's 66 now. Oh, 66.
1966. He was born in the year 1966.
69 years of age. 44 and 25.
Okay. Yes, what do you want?
Report has to be called for you.
Call for a report, huh? Call for a report. Yes, next.
23.
One more chance for the report.
No report has come, huh?
No.
Pursuant to the order dated 3/7/2025. The report has not come. Please give back. None appears for the appellant. Yeah. Report.
20.
Not complied. Not complied. Yes.
24.
24 minutes, a report has to be called for.
No, why report? What is the age?
Yes, 61 and 57.
61?
And 57.
See, all the matters of your office I have listed.
Yes.
If only the reports have to be called, then I will be unemployed by lunch. What is this? You told that you will argue the matters.
Let's have.
See, the appellants with those age is more than 65. I'm generally asking for the report.
Let's.
Presume that they are surviving.
Let's.
Argue it. Are
I'll
you
do-
ready or not?
I'll do it after lunch, my lord.
No,
After
I'll
lunch.
pass it over. How many matters you will do after lunch?
2 matters.
Now 3-4 matters I have already passed over. Anyway, yes, next. 25,
25.
very old matter.
25 instruction is yet to see.
Report has come, madam.
No, not yet.
3/7/25 not compliant. Last time you didn't appear. Give your appearance. Yes.
27.
May I please, your lordship? I am appearing on behalf of Mr. Panda, appearing to visit today. I respectfully seek for a passover in this matter.
Passover.
Your
Yes. 20.
28.
much.
Yes.
Kindly adjourn. If a report needs to be called, is 61 years of age.
You are
Otherwise-
34 in the year 1998.
Judgment.
32 in the year 1999. Call for a report. Yes. Next. Next. Report.
31.
My lord, respecting your previous order, my lord, I'm massing up all my confidences. I have prepared somehow and let this be appreciated. Even though I am not
31.
well versed with the criminal cases and everything.
Yes. Sorry. What do you want?
My lord, last time your lordship has directed me to proceed with the case so far as the appeal, instant appeal is concerned. That is 206 of 1999. Instant appeal. So that is, my lord, before I submit something, let me, on a lighter note, I would like to submit that when the cases of 376 or even the 354 or any other cases are being dealt with, it must be dealt with a lot of diligence and carefulness. That is not been done over here, my lord, in the instant case. A lot of contradictions are there. Even though the 164 statement and the medical report it doesn't corroborate, and the victim lady also not told about this thing before the IO and the medical officer, and the examination report.
I didn't follow you. Are you arguing the matter or giving a lecture?
No, no, my lord.
Argue the matter. I don't have that kind of time. to
Exactly.
sit around.
I'm putting the facts of this appeal.
Take out your file and argue. Give the file. Give
No,
the
my
file.
lord. I have with me.
Either you argue the matter or seek an adjournment.
Obliged, ma'am.
I don't have that kind of time to listen to all this. Either you have the file, take it out the file and argue.
My lord,
These are the matters pending since 1999.
Obliged. That's correct, my lord. That the judgment.
Take out the file.
Judgment of conviction, my lord. The sentence passed by the learned trial court below are very much illegal and contrary to the law, as against the weightage of evidences on record.
Yes.
And the learned trial court should have convicted the appellant relying on the evidence of the prosecutory acts without any independent corroboration, as such the impound or the conviction and sentence passed thereon are liable to be set aside. And the learned trial court, in view of his own finding.
Come to the prosecutory statement. Come to the prosecutory item. Take out the trial court. Who is the prosecutor?
My lord, the wife of the informant.
I know which witness. PW?
PW5.
PW5? Yes. Let us read it.
Sabita Raut, my lord.
Yes. Read it.
ମୁଁ ଆଜକୁ 1 ବର୍ଷ ହେଲା ସାନ ମଙ୍ଗରାଜପୁର ସାମିଲ
What are you reading?
statement of Sabita Raut, Given before police. 4394 given to PS Kendrapada 161.
Now you are convicted. Read the evidence. 161 statement. I'll see if there is any contradiction, whether you are confronted with that statement or not. Now you read the evidence.
So for
I
that,
will not decide the case on the basis of 161 now.
okay.
I have to decide the case on the basis of substantive evidence which has come on record. Read.
But that is not I could find it. Can I pray, my lord, 3 days period of time, my lord, so that on Friday I could submit it before.
You read the 161 statement and
No, my lord, I couldn't find the.
make up your mind.
That
that
I know
you
well.
good case or
No,
bad
my
case.
lord, I may be excused. I'm not well versed with the criminal cases, as because on that date I was on seeking time for Mr. Ishan Mahanti, and your lordship was. So let 3 days time may kindly be given to satisfy your lordship.
Yes.
Obliged.
32.
Yes. 32. Amrish Kumar. None appeals for the appellant. Please the matter for hearing. It's for next date appearing in NDPS. Yes. Amicus curiae will be appointed. Yes.
33.
Lordship, on behalf of Mr. Chand, I seek 1 week adjournment. 1 week of adjournment.
Police asking for. See, these are the 99 matter. Why are you seeking adjournment? I don't know.
Lordship, also for item 45.
I first of all think whether I will give adjournment in this matter or not. Don't be very ambitious. 99 matters. What is the offense? Let us see.
Instruction also not received.
A complete case. On behalf of Mr. Jan, adjournment is sought. Please see. Sorted the order. Sorted. Huh? But let it come. And make sure that no further adjournments are granted on the next date of hearing. Any by any cost. Yes.
3 months,
Next.
100.
34.
34.
Yes.
Not touch of
Yeah, 60 years.
60.
I asked for a report.
Call for it.
Call for report.
35.
52 to 9.
Yes. 35.
Yes, Your Lordship. Item number 35, report was called for.
62, 66 years, 62.
I have asked you for a report.
Report.
Have you got it?
No, first time.
Not first time. 3/7/2025, the order was passed.
Yes.
No, not recent.
Madam, you have to see it.
Just 3 to 4 days. Next week.
3/7/2025. Order has not been complied. You people are sending letters or not? The State Council, are you sending the letters pursuant to the orders? The 3/7/2025 order was passed.
Letters.
In some
issue.
cases, we are yet to get the instructions. We are following it.
See, I told last time, see, this is about 1 month. Within 1 month, no report is coming forth.
One last. But should we call it on Thursday? We'll get it.
And the Director General of Police has assured that all the report will be complied within 1 week.
We'll follow it up positively, Your Lordship. Let me post this matter to Thursday, Your Lordship. We'll get it.
Thursday, how can you get 3/7 order? 19th I'm giving. And only this July month I'm tolerating. Next, from August onwards, I'll all the respective, SPs to appear in court. Okay.
We'll make sure that the reports are here.
Yes, next. About 550 reports are pending. 550 reports are pending. Yes, imagine.
36 also not received, but
36,
letter you
Lordship,
understood.
I'm ready with 36.
But I was appearing for the appellate. Last occasion I missed the list, your lordship was the
She will be happy to assist you, sir.
No, I don't mind.
But she learned something from you.
Yes, probably appellant number 1 was 49 years. Appellant number 2 was 54 years.
Then means which year?
99.
1999.
99.
Well, then must be very old then.
Yes.
Get a report, madam. And Mr. D.K. Mishra appearing for the appellant submits that on the last date of last 2 occasions he could not appear. Therefore, Mr. Mahapatra has been appointed in a case query. On the request of the court, Mr. Mahapatra agreed to assist Mr. D.K. Mishra. Even if you are not there, she is competent.
37.
7, my lord, my last occasion I missed the list. The one of the appellant is presently, my lord.
Yes.
Instruction not received.
What is the age?
One is 39 years in 2000. Another is 30 years. He must be 55 right now. The appellant number 2. Appellant number 1 is.
They must be in 50s.
64. Appellant number 1 is 64.
Are you ready?
No, my lord.
What is this, man?
It is offense under section 324.
324.
326 and
convicted
294. 2 years maximum prison.
326.
2 years, 1,000.
Injury?
Injury, my lord, right hand, there's a right hand they have attacked with the sword. And there is a 10 centimeter and depth around 4 centimeter.
What is the weapon?
Sword.
So, 320. Call for report. Call for report. Yes. Yes. Report. Yes.
38.
Yes, madam. Report.
Death report received from the town PS police.
Give me. Get the report. There.
Last occasion, 28/7/25. नहीं, आज हाँ 24/7/25. हाँ ये कहाँ होता? परफॉर्मेंस तो लाइक हाँ वो तो पे certificate instruction.
We have the report.
Report.
Give that. Persons to the order dated 3/7/2025. IIC Town PS Balishov has submitted a written report inter alia stating therein that the sole appellant Jagdish Prasad Sharma has expired on 26/6/2023. The only appellant is Jagdish Sharma, na?
Only they filed a city.
He's expired on 26.
Only
And his wife also
only-
expired on, why,
only-
why? The report is taken on record, if it stands evident, yes. Yes.
40.
Your Lordship,
only this one. Yeah, CG.
40. 50 is equal. Have you prepared the chart?
That's in the number.
58 was settled.
Okay.
So, 57.
The call for a report, madam. In 2000, the appellant was 68 years old. Call for a report. The item 40.
40, item 40.
I
Item
order
40.
no- There is no order, nothing.
Yes, sir.
Where is the order? What is? Not approved. Yes, madam, you got the report?
41, no, 41, 61 years and 85%, not received the report.
No, I'm talking about 40. Panchanan Pradhan.
No. That what it should but not
2025.
received.
Last opportunity. And yes.
41.
41.
61 years and 85 years. 41, now 61 years and 85 years.
Got the report or not?
No.
Hmm?
No.
The report has.
नहीं रिपोर्ट ଆସିବ ନା
report. Let the report come.
ଚିଠି ପଠେଇଦେଲେ ମଧ୍ୟ ସେ ମଧ୍ୟ ଫେରି ଆସିଲା ଆଜ୍ଞା।
Let. Yes.
ସରୋଜ କୁମାର
You are for the next, second item.
ଆଜ୍ଞା।
Suraj Kumar. And,
Report, sir.
Mr. Kotkia will be appear in the first item. Sudhanshu. What is the offense, Mr. Kotkia?
That is section 7 of Essential Commodities Act related with paddy control order. And 3 months.
In both the cases.
PO Act is squarely applicable.
What about the second case? Same.
The conduct counsel is Mr. Anand Bhuya. He is no more, my lord.
No, why it is tagged then?
File is
500.
Why it is tagged?
There are other persons involved. There are total 5 persons are accused persons. The present in this case, Sudhanshu Sekar Behra, he was the government official SCSO, Assistant Civil Supply Officer at that point of time. So it is 6 quintal.
Suraj Kumar Das is also a officer.
Yes, boss.
Yes.
SCSO.
So you are covered by which judgment you are saying?
Pardon?
Covered by which judgment?
That is plus covered by the judgment. There is Jagannath Mandal versus Orissa that has been passed by the Supreme Court on 3rd May 2023. In CRA number 148 of 1984. Relying upon the judgment that is 1987 SCC Online Orissa 144. T. Sushila Patra versus State. That is even applicable in SC Act. PO Act is applicable.
PO, if you agree, then I'll.
Administration is applicable.
If you agree, then I'll grant PO. Reporter. Short date the bill. 5th.
60 years old age by now.
No, there are some government officers are also there, it seems.
Section 12 is protection of. Plus I have had one.
So therefore, they may have some service benefit and whatever. Yes.
42.
43.
42. Hold on. Yes. 42. Pass on. Yes.
43.
43, your lordship, file order dated 3/7/2025, call for the whereabouts, but not yet received, your lordship.
Have you sent the letters?
But at that point of time on 3/7, the file was not restored by our official. What happened?
Have you sent the letter or not?
Lordship, I may kindly glance for a moment. What are the difficulties of our official, lordship? On the first 3/7/2025, there is no file supplied to us. Therefore, though the order of the Honorable Court, we are not able to send the letter, lordship. First, my only praying for 1 week time.
2025 order not complied.
Yes, that is the whole difficulty, lordship. Therefore, letter could not be issued, your lordship.
Yes.
44.
Before the CBI, lordship. Before on behalf of CBI, lordship, the appellant is died, but the death certificate could not be retrieved from his wife. So efforts are being made to produce the death certificate of the appellant. As per instruction that he has expired, but death certificate has not been received.
CBI,
lordship, on behalf of CBI.
I will record your statement.
I have instructed to submit this, but I have not received the.
Get a written instruction Thursday. Complete it, close it. Thursday. Learned counsel for the CBI submits that the sole appellant in the present case, Bharat Bhushan Satpathy, has already expired. However, he has not received he has received the oral instruction. However, there is no written instruction he has received as yet. Leave the matter day after. Get written note.
45.
45, your lordship. Initially, the accused appellants are faced the trial 302 and 34 and 114 of the IPC. The London Trial Court convicted under section 304 part 2 and 34, your lordship. Against that, the state is preferred the CRLLP. And against there is a GCRL is pending for the Honorable Division Bench, your lordship. Now the present CRL will come for against the 304 part 2 and 34, your lordship. Conviction for 7 years.
What is pending? Against
GCRL is pending, your lordship, on the behest of the state is filed, though charge has been framed 302, but conviction is made 304 part 2. Therefore, the present state has filed the CRLLP.
What is happening there?
That is, your lordship, come with that brief, your lordship. There is a noting is that a division bench matter placed here for reference, your lordship. GCRL is 6 of 2003, your lordship.
Then unless it is decided
Yes,
by
your lordship,
division
that
bench,
is the
I
whole
can't decide.
difficulty, lordship, because 304 part 2 against that.
Against the acquittal under 302.
Yes, your lordship.
Against the acquittal.
Yes, your lordship.
Let us counsel for the state, Mr. Mahanti submits that against the judgment of acquittal on the charges of section 302 IPC, is government criminal appeal is pending before division bench, being GCRLA number 6 of 2003. This matter may await the outcome of the said appeal. Since the GCRLA appeal is pending before the division bench, I feel it appropriate to leave the present appeal along with the GCRLA number 6 of 6 of 2003 before the division bench of this court. I am sending it to division bench. Let division bench decide it. Okay. Both the matters. Please the present appeal along with the GCRLA 2003 before the concerned division bench. Yes. Assigned division bench. Yes.
46.
Wait, 46, my lord, I'll come to order dated
Order report.
July
1
2025.
minute.
Not yet received, your lordship, whereabouts of the
3/7/2025 order not complied. Last opportunity. Yes.
My lord, I also misplaced the file.
Let him get the report.
47.
Yes. 47 also, your lordship, last occasion, lordship, 3/7/2025, your lordship directed and called for whereabouts of the appellant, not yet received, your lordship.
3/7 not complied. Yes.
48.
Have you given the letters or not?
In this case, on that day, your lordship, file had not supplied by the office to us. Therefore,
Very nice.
the lordship could not able
You have to set
No,
your
today, I'm let it come next week, lordship. I'll ensure to collect
Like 48, huh?
concerned police station.
48.
48.
Yes.
Vigilance matter.
Yes.
There is a move, private verification. Private party is there for details.
Report.
There is 48
Private-
lordship, the
private
private party is there.
Complainant what?
Perhaps averaging out of 138%. Averaging out of a complaint case 493 IPC. Arrive for 3 years.
3 years. Non-APS for the appellant on the last date of hearing, that is on 24/7/2025, and before also non-appeared. Therefore, this court indicated that MHS will be appointed. So and so is appointed and charge of release the Mokoi. Yes. Yeah, next.
49.
In item 49, the offences, the appellant convicted for the offence 376 of IPC, arrived for 3 years, the sentence has been passed. Lordship, I am praying for 3 days time to arrange,
3 days time?
to prepare.
You have the file with you.
Yes.
Don't appears and seeks an adjournment to address the court in the instead of a release.
50.
Thank you, Your Lordship. Here the appellant has been convicted on section 506, 511 and 354 IPC, and he has sentenced to undergo RI for 2 years. Your Lordship, order sheet of 20, order dated 21/9/2005 reveals that he has already been in custody for more than 1 year and 9 months.
1 year, 9 months.
Yes, Your Lordship.
Sole appellant, huh?
Yes, Your Lordship. Sole appellant.
No Kishore Pradhan for 2 years. Why then? Yes. Yes. Convicted
Under section 354,
354.
and 511.
506. What is the sentence?
2 years, rigorous imprisonment for 2 years.
2 years.
Yes, Your Lordship.
And fine also.
Fine of 50.
See, what is the nature of the allegation? Let us see who is the prosecutrix. The Navakishore. Let us see the evidence of prosecutrix.
Lordship, 8 numbers of witnesses have been examined from the side of prosecution, out of whom PW1 is the informant, PW7 is the doctor who has examined the victim, and PW8 is
Who is victim? 1.
PW1.
Informant. Just read. Let us get the idea what is the allegation. Note.
I know the accused. About 1 year back, myself, my husband, and our 2 children were staying in the house of accused on rent at Punnamagate, Bhubaneswar, Bhimeshwar Basti for 10 months. Thereafter, we built a house on the railway land in the same basti and left the house of accused. The house of where we stayed on rent and our present house are intervened by 20 other houses. 7 to 8 months back, at about 9:30 p.m., my husband was absent in the house and went on his fish business. My children were sleeping and I was sitting in my house. The accused came, stood at the doorway, which was open, them, and asked me, Jio Sunilu? Then I told him, Bhai kaun hela? When we were staying in the house of accused on rent, the father of the accused, who has no daughter, was treating me as his daughter. Then
Okay. This
Exhibit 7.
Exhibit 3 is the doctor's report, Your Honor.
Yes. Exhibit?
3, the
Yes.
PW7 is the doctor's report. That is digital page 91. Also.
Yes.
The doctor has examined the victim, has stated that there is no sign and pursuit sexual intercourse at present.
Only this much, huh? But this was done on 17/1/2004,
Yes, sir.
after 7 days.
11/1 is the date of occurrence.
6 days. 6 days, yes.
The rental report disbelieves 376 on the grounds
Hmm.
that though the PW1 and her husband PW3 7 is corroborated, but there is that is dealt with in paragraph in the internal page of 9 of the judgment, Your Lordship.
9 of the judgment.
Internal page of the judgment, Your Lordship, running page 19.
Yes.
Read.
Read it.
May I read it?
Yes.
Evidence of PW1 and PW3 came to know regarding the commission of such rape by
Which
the
paragraph you are reading?
That is, your lordship, starts from paragraph, your lordship, previous page, is internal page of the judgment 8, that paragraph, your lordship, 9.
Okay, para 9. Coming to the challenge of rape.
Yes, your lordship.
It seems that there was a direct allegation of the rape in the report of as per the wording of the report. That Modesty was completely outraged during the evidence in the court number 1. Court Peter 1 directly stated that the accused committed rape on her by making her naked and by opening his pant, and further she has stated that his time comes on. Read it. Regarding the
may I read your lordship as relevant
PW
from
3
person?
corroborated and PW 1 and 3 came to regarding the commission of such rape of PW 1 has deposed her because was torn, and that was biting mark on her chest. There was a biting mark on her chest. Where from it is got biting mark? Her name? Yes.
1 Milords. This had come up on last Thursday, Milords. The applicant is in person before my lords. Milords, the appellant is in person before my lords. It reflects from the cause list. Milords had indicated that for me to argue the matter, Milords. But
What is the offense?
3 years are under 324 IPC.
But last time none appeared.
No, I appeared, Milords. I informed Milords that this person, the appellant is in person before my lords. That's why of the opinion that asked me to conduct the matter and would have appointed, yes.
Then, are you ready now?
Let's may call it on Thursday, day after. I'll do the matter.
Mr. Roy, the counsel who has been appointed as an MF history in the matter, seeks an adjournment, briefly matter. Yes. Yes.
52.
1 minute.
Yes.
We are unable to contact the petitioner lordship. Another week's time will be granted.
What is the age up for the appellant?
Lordship, then they 57, now they are 71 and 76.
Then I'll go get a report. Get a report. Huh? Get a report. Get a report. Yes.
53.
Send the letters today itself.
Yes, sir, 50. Yes. 52, my vigilance is there. 52, your lordship. 53, state.
Whatever.
Yes, your lordship.
Yes. Report.
No, lordship. Last, no report.
17,725.
Lordship.
Order, not comply.
Lordship.
Thereafter 15,725. The state was directed to obtain instructions regarding the whereabout and well-being of the appellant by the order dated 17/7/2025, and subsequently again it was repeated on 15/7/2025. How can it be?
15,
how there are two orders, 17/7/25 and 15/7/25? Why there are two orders? Which will the file close here? Huh?
15/7 plus 15/7 it was ordered from.
No. 15/7 the order. Okay. 15/7/2025, and thereafter again on 17/7/25. However, the state council again seeks an adjournment for obtaining the instruction by way of last and final opportunity. 1 week time is granted to the state council to obtain instruction, dealing with which police station is this? Failing which the IIC of Teltuli police station shall appear in person through visual mode to explain as to why the report has not been submitted as yet. Week of it. 1 week after 1 week. He will appear. Give a date. Personal appearance.
I will ensure.
IIC this time. Next time the SP. Okay.
55.
May I please, your lords?
Yes.
Here, I got the information that the Appellant has already expired in the meantime. Last occasion also I placed before your lordship. My lord, your lordship had directed the state council because I am unable
got
to
it. That's no.
get the contact.
What is happening with you people? I don't understand.
18/7, your lordship directed to obtain.
Have you written a letter?
Yes, already wrote letter. That is there.
Letter to whom you have written?
To IAC and SP, your lordship, concerned.
When?
18/7, your lordship. Letter was issued in 19/7/2025, your lordship.
18/7.
Yes, your lordship. This honorable court directed to take instruction. We have issued letter 19/7/2025.
What is happening? Why?
Follow up, lordship, by enforce the.
Which police station?
Your lordship, that is
The IIC. NDPS, I don't.
IAC Junagadh, your lordship. in the writ of Pala.
Mr. P.K. Mishra, that the counsel appealing for the appellant submits that although he got oral instruction that the appellant has already expired, but for the purpose of confirmation of the same, the state council was directed to obtain instruction. Mr. Mahanti, letter counsel for the state, submits that he has already addressed a letter to
Superintendent of Police, Kalahandi, your lordship.
Kalahandi and
IAC Junagadh. IAC Junagadh.
On 18/7, 2025. However, no report has been furnished by them. In that view of the matter, the IAC
Junagadh. Yes, your lord.
Shall appear before the court through virtual mode on the next date appearing. Next Tuesday. Next Tuesday. Appear. Yes.
Okay.
Free copy of the order.
Yes.
56.
Lordship, last occurrence status report was asked.
Yes.
On the last occurrence on 17/7/2025.
Yes. Got the report?
56, your lordship. No, your lordship, no report will receive. No report.
When have you given the
8/7, your lordship. 18/7.
18/7.
Lordship.
17/7 the order, 18/7 you have given.
Yes, your lordship.
Given to whom?
To Superintendent of Police Kalahandi and so also 56th. And Junagadh Police, your lordship, Kalahandi.
Same order of the white order dated 17/7/2025. Direction was issued to the state state for obtaining instruction regarding the whereabout and the well-being of the appellant and persons thereto. The state council had issued a letter dated 18/7/2025. However, no instruction has yet been received. Therefore, the IIC
Junagadh Police Station, lordship.
Junagadh Police Station is directed to appear through virtual mode on the next date appearing. Next Tuesday. Next Tuesday.
57.
57 minutes may kindly call it day after on Thursday.
Why?
That's in the case A1 and A2, two applicants have been convicted of under offense 323 with 34 for 2 months. A3 has been convicted of 354 for 4 months. Take 1 day to.
Undergone period have you find out?
I'll find out from the LCR.
Okay, next Thursday. Yes.
Great.
Coming Thursday. Day after.
Day after.
Okay. Yes. 59.
59.
Call for a report 59.
Yes, ma'am. Sure.
60.
60. Yes, 60. He's only 51 years.
It is 498A, my lordship. 2 years and his fine.
Non-appeals for the appellant when the matter was called up. In the interest of this judge, on the next date appearing, nobody appears. MIK school will be appointed. Give 19th of yes.
62.
37.
62.
62.
Yes, may I please?
Yes.
But here the charge was 366A, but it was disbelieved by the learned trial court, and only charge under 363 kidnapping that was established, and the punishment rigorous imprisonment of 3 years and
Fine of
2,000 rupees fine.
Yes, anything want to say?
No, my lordship, 2,000 rupees fine, kidnapping.
Okay.
It's a case that the ingredients of 363 is not made out against the accused person. That is my submission, Your Lordship. So here the prosecution case in short is that, well, on 1/10/2006, the daughter of the informant, she was alleged to be kidnapped by the accused person. On that very same date, she was found out and the accused was arrested, my lord. And the substratum of the allegation is that she was underage, 18 years old college level. That was the case. And if your lordship looks at page number 8 of the judgment itself.
Judgment?
Yes, sir.
Yes.
Sorry, I'm sorry. Page number 13.
13, huh?
13, 1 Internal page 30.
Para?
Paragraph.
Give the file.
Para 12, bro, second question. In view of lack of evidence in respect of the fourth ingredient of the offense under 366A of the IPC, it is to be held that the prosecution is failed to substantiate the charge under section 366A of IPC against the accused. How the
1 minute, 1 minute.
Wrong sentence.
It's party name?
Yes, sir. Failed to substantiate the charge under.
No, party name.
Sushant Malik.
Shanta Kumar.
Yes.
Sushant Malik.
Sushanta Malik.
Yes, I got it. Yes, I got it. Which paragraph you are reading?
Paragraph number 12, page number 13. That is the.
Okay. 12.
13 second line, in view of. In view of the lack of evidence in respect of the fourth ingredient of the offense under section 366A of the IPC, it is to be held that the prosecution has failed to substantiate the charge under section 366A of IPC against the accused. However, the prosecution has successfully proved the other three ingredients which constitute the offense punishable under section 363 of IPC. In order to substantiate the charge under section 363 of IPC, it is to be proved that at the time of the offense, a minor under 16 years of age, if a male, or under 18 years of age, if a female, or the said person was of unsound mind, has been kidnapped from lawful guardianship or from India. In the instant case, the prosecution has been able to prove the victim was under 18 years of age on the date of occurrence, and she was taken out of keeping of
The lawful guardianship
without the
Consent of such guardianship.
From the evidence
from
of
the evidence, the parents of the victim, crystal clear the victim is taken away with the accused without their knowledge or consent.
Yes.
And that is the
For that, my, yes.
Show me evidence.
Yes, yes. First, Your Lordship, that PW5, PW5, for my lord. How the case has been made out, how the case has been concocted. That I will show my number.
He is the brother-in-law of the informant.
Yes, that he first saw the kidnapping.
PW?
PW5.
5 is the brother-in-law
of the informant. He has on first, he has seen that the victim is kidnapped by the
with the accused in a bicycle.
in a bicycle.
Eyewitness kind.
Yes.
Eyewitness.
Yes.
From the paragraph number 1 itself, that PW5.
Yes.
I know the accused who is my neighborhood. The informant is my brother-in-law, Sumitra, that the victim. Sumitra is the daughter of the informant. The case incident took place in the midnight of.
What is the name of this witness?
The witness.
Mani Malik.
Hon'Ble.
1 minute.
PW5, my lord.
1 minute, 1 minute. Sushant Kumar, na? Or Sushant Kumar. PW5, huh?
Yes, sir.
This is ST case number?
ST case. City case number. City case number 3/5 of 2007.
Paragraph, this is regarding something else, yeah. No, this is something else. The record of some other cases now attached. Just see. Just see the trial court record.
Here the trial court record is not here, only the appeal. In this
Trial-
system, that
trial-
system trial court record.
Trial court record, just see. Find out. PW 5 is someone else. And the record pertains to some other case.
Then
Record
let the
pertains
record
to
be
some other case.
ST case number is also different.
Different. There the accused is Manoj Pradhan and Kali, Praful Malik. And the offense is something else.
record mix up is
Correct the record. Huh? While hearing of the appeal, it is the 302 case. While hearing the appeal, it is discovered that the trial court record attached with the file pertains to some other case. And the registry is directed to place the appropriate trial court record. Copy of the appropriate trial court release the matter for hearing. Let us find out the record. Yes, sir.
Your lordship is calling the matter.
I'll give you a date.
Well,
yes.
Sir, if I may pray one thing, in the meantime, if the status can be called for that.
What it is?
22
Chandra,
by
22 hitla, 15 years.
37 years.
Yes.
Yes. Yes.
65.
65. No,
Say
what about 64? Call for it. But call for a report, 64. Call for a report.
Sir, I prefer next 2 minutes. I
Which
can
one?
55 minutes.
Okay. 65 on request. And then yes, 66. 66. Yes, Mr. Ponda.
67.
67. Okay.
66.
6.
The year 2010 is 40, my lordship.
Pass over. 67.
67.
May I please, your lordship? Your lordship,
yes.
The appellants are convicted under section 452, 332 by 34 of IPC, your lordship. The facts of the case, your lordship, the appellants have the villager of Balagar, Luda, in the night, while the informant was in his official residence, they entered forcibly and assaulted by saying the caste and abusing in filthy languages, your lordship. Accordingly, the informant prepared a FIR and lodged the FIR before the IIC, Balagoda police station, your lordship.
Yes.
Accordingly,
They are convicted under which provision?
My lord, commit
452, 332 and 34 of
34,
452.
452,
52, 332 and 34.
34 IPC, your lordship.
And SC Act?
Yeah, yes, they are reputed by
Reputed.
to that.
What is
My
the
humble
sentence?
submission before
Let us see the sentence.
Sentence, the 1 year, your lordship. My
1 year.
kindly periods, the evidence, there is no any credible evidence against the petitioner, appellants, your lordship. All the PWs are hostile to the prosecution and only basing upon the statement of the PW number 6 with the informant, conviction was made. And here, your lordship, the statement which was adduced by the opposite informant in para 11 is specifically stated that at the time of incident, he called for the telephone message to the police station. But the IO, opposite party number evidence, PW number 8, your lordship, is the IO, he specifically stated that he was not called by the any telephonic message was not there. And there is no evidence to the case, your lordship. And the informant specifically stated that his driver and 1 peon was present at the time of.
Let us see how the trial court deals with it.
My lord.
Which paragraph? You have relied upon PW 6 and 8.
My lord. 6 and 8, your lord.
5, 6 and 8.
My lord.
Yeah, let us.
6, 7,
You have
6.
filed 3. Yes. Let us see the trial court.
My lord.
Yes. Which part?
Page number 23, para 12 is
23.
PW 6,
Yes.
para 12.
Para 2 night 12 lakhs.
12, 1 to 12.
1 2.
Para
My
12, huh?
Yes.
For 12, your lordship. I am placing your lordship. It
Yes.
is, however, proved by the prosecution that PW6, who is a public servant, while looking to the official guard sitting in the official residence, the accused persons entered inside and they assaulted him. It is further proved that the accused person made their entry with a view to assault PW6, who is a public servant and the video of the Bolagod block. Therefore, prosecution is able to prove the charge under section 452, 332 by 34 of IPC against the accused person. 13, your lordship. In view of my above discussion, I am therefore inclined to hold that prosecution is not able to prove the case against the accused persons under section 294, 186, 506, 341, 34 of IPC and under section 31X, SC and ST, PA Act 34 of IPC, and they are acquitted therefore.
Yes, come to page 16, para 6.
Para 6.
Para 6.
My lord.
I have gone through the evidence adduced by the prosecution carefully. Read it. PW 2 and 3.
2 and
3, 4 and 5.
My lord, all are hostile to the prosecution.
Who are said to be the occurrence witnesses have turned hostile.
My lord.
And they have not deposed, turned hostile, and they have not deposed anything about the occurrence. PW6 and who is the informant in the present case is specifically and categorically supported the prosecution case. And, he stated that on so and so, about so and so, while he was looking to his official duct in his official residence situated in so and so, both the accused persons came and abused him as so and so. And he further stated that their challenge as to why the kerosene oil is not supplied to so and so Gram Panchayat, and when he
This is the sole
so verified and they
Yes,
directed him to so and so. Also stated that about so and so and why the accused persons responded blow and given a blow to the door and for the door open, and he was stated in paragraph 5. The evidence that the tutu was aiming at the fist blow to his face, but he slightly bent his face and downwards so and so. The fist blow fell on the front head, forehead. And he stated that he is not going to the drawing room, and the accused Manu pulled his banyan, and a result of which is stone. And I've gone through the examination of a witness also, how so and so, disbelieved and so and so. Yes.
And the deposition, my lordship, can be performed.
Why PW6 will be disbelieved?
Yes.
My lord, the sole grievance, your lordship.
In the deposition also he has said.
Yes.
Medical report and his statement, particularly, is not corroborated with each other, your lordship.
What is who is the
My lord, I am placing your lordship. The FIR. No, I am
PW? Let us see PW.
My lord, kindly peruse the FIR, your lordship. In the FIR, your lordship, the informant specifically stated that the PW number 4 and 5 was present at the time of his halla.
PW?
4 and 5.
And they did not support.
Did not support. This is the main crux of the case, your lordship, because he added them, though they are not present.
You own over them. But how will you doubt PW6 with the video? He has no enmity with you. You went to inside the house. You misbehaved with him.
My lord.
And medical reports also prove, my lordship.
How much you have undergone, you tell me. This is the case for
Jaine. From the beginning, I went back. Any lenient 1 year.
1 year sentence?
1 year.
Yes.
I'll grant the provision. I'll give provision.
But
what are you doing, by the way?
I am a public one. Come course.
No, you are employed somewhere. You
No.
don't employ anything of that sort.
Totally move. Totally 10-15 ବର୍ଷ ପରେ first time ଆସିଛି ହଜୁର. Totally ମୁଁ ପୁରା ଦେଖିନି case ଟା.
33 years and 40 years at the time 2000. 2000?
10.
No. Incident happened somewhere in 2002. 2002, that's point in time. So now they must be about in their 60s. one must be in the early 50s and must be 60s. I'll grant probation, Mr. Punda.
My lord.
You want to say anything? Will you verify whether they are government employee or anything?
No, I have to verify, your lordship.
I'll put it on Thursday, day after tomorrow. You tell me, I'll give PO. Seek instruction and tell. Okay. More than 30%. Only limited to that.
My
Get the instruction. I am ready to give you probation.
My
Okay.
lord, my lord.
Yes. 70.
67, 68.
Yeah, please, my lord.
Yes.
The appellants, appellant number 3, at the time of appeal filing of 53 years. Now 68. Other appellants.
Now, one of them is 68.
That.
The rest two are in their 40s. I'll call for a
42.
report then. Call for report. Call for report.
My lord, the offense conviction is
Yes.
to undergo SI for a period of 6 months and to pay fine of rupees 1,000. In default to undergo SI for 1 month for the offense under section 31X of SC/STP Act. Further, I sentence each of to undergo SI for a period of 6 months to pay a fine of rupees under section 323 and 342 IPC.
1 month.
The occurrence took place due to stolen of a mobile phone. I pray release the one PO.
No, SC/ST I can't give it. There is a bar.
Bar PO. I ready for hearing day after tomorrow.
There is a bar. That's the problem. Otherwise,
Day after tomorrow, I'm ready for it.
if you can get some kind of, but the statutory bar, how can you?
Day after tomorrow.
Then will you argue it?
Or a period undergone how many days?
How much you have undergone? You tell me.
LCR.
LCR is there. LCR is there. The record. Find out. Find out for some time. Okay. I'll put it day after tomorrow. Only to undergone period. Tuesday. Next Tuesday. Next Tuesday. Our technical team is there. They will assist you. Just check it out.
I am new. In technical, I am new.
Just check it up. Spend 5-10 minutes. You will get it. Next Tuesday. Huh? Next Tuesday you will tell me undergone period. Next.
70.
Just find out. And give it. 70.
70, my lord. At that time 44. Now 60. Lordship call for a report, my lord. 320 रे 2 वर्ष होइछि चार्ज फ्रेम हेतला 360 326 चार्ज has been altered and convicted under section 324 2 years, my lord. Lordship
Call for report. Call for report. Yes.
71.
71, my lord. I am appealing through BC, my lord. In this case, we don't have any instruction, my lord.
Here also call for report. Call for report. Yes.
72.
72.
Item 7. My lord, may I audible,
Yes,
my
sir.
lord?
Yes, yes.
Item 72 file the appeal. Lordship may allow it is arising out of the Kandhamal riots, and conviction is made. In some cases we have already been acquitted, my lord. Lordship, give few days time. We will prepare and we will submit the note and along with our.
You are convicted under which for which offences?
Yes, that's why I will not reduce.
428.
428. Give some time.
427, 148, 147.
Writing and all. Okay. Mr. Party seeks adjournment as is exclusive, right? This the matter. How the experience? Yes.
Madam, may pardon. Item 16, I may.
47, 148, 427, 330.
Forget to take the LCR on pen drive. My friend will take. So that it will be easier.
Keep shift. Yes.
My
Today only
lord,
you take it.
I'll take a day after tomorrow.
My lord is adjourning to some other day.
First happen.
Thursday undergone only. He will tell me the undergone. He will
Only
not
I
argue.
say.
If there is a case of argument, I will adjourn. Okay. Yes.
Item 72, my lord, adjourn to which date?
Give a date.
22.
22nd August.
Yes,
Get
ma'am.
ready.
73.
73 millets, appellant number 2, 77 years and 3, 88 years.
77
years.
What is the item number? 73.
73.
Okay. Get a report, huh? Get a
Yes.
report. Yes. 74.
74.
74 is also similar.
74 also, my lord, may pick you 22nd.
22nd. The same
74
Kandamal, right?
and 75 both. Yes, Kandamal trial.
25 also.
Well,
Kandamal,
SST
both.
could all complete the hearing. Yes.
All the three matters, 22nd. Yes.
74 and 75 both.
74, 75. Okay.
76.
76, appellant is 69 years old, my lord.
Get a report.
Report.
Okay.
73.
76 report. Yes.
77.
Lordship, 77, I seek for an adjournment because we.
Report is.
I read, got the report.
80, no.
Get a
first
report.
time,
Get
first.
it. 84, 85, 80, and yes. Get a report. Yes.
78.
Here also.
Get a report here. Two of them are
79.
79.
79 also report from the appellant number 4, 79 years old.
Get report. Okay.
80.
Get report.
I am on behalf of.
Report 79 years.
8 also report.
79.
At the time of judgment, 57 years.
Now 79.
My lord,
79 years.
78.
81.
1 minute.
81.
Under section 354 IPC.
354.
Arrive for 2 years.
Years and fine.
And fine.
Minute,
Yes.
some time required, minute. No, file is not with me. I'll take.
What is the sentence?
2 years.
2 years.
2 years.
Do you have any idea? Undergone period?
Yes, I'll verify, my lord, their custody period.
When do you want?
Next
22nd.
yes, ma'am.
22nd August. Oh, no, the appeal is 2010. Okay. 22nd.
82.
82. 82 you have to get a report.
Report.
Get a report. Mr. Dhar, where is Mr. Dhar? How many matters are now? 5 matters. Go to 5 matters. 5 matters. Go to item.
Item 10.
10.
14.
1 minute. 10, 14.
24.
10, 14,
24.
24,
27.
24, 27,
And 42.
and 42. 42. 5 matters for hearing. Get ready. These 5 matters are there for hearing. Whoever is appearing, get ready.
Yes, ma'am.
All the 5 matters are there. Your matter is there. I'll hear it. Huh? Item 66. Wait,
Start. Second. Item 10.
10.
Item 10.
Yeah. Right.
Great pleasure. Here, my lord, the present appellants and 60 others. They were placed to trial in the court of additional
60.
60.
Paperwork is there? This.
The appellants, they are 10 in number.
Hmm.
Along with 60 others were placed on the trial in the court of additional sessions Judge Kendrapada, being charged under section 454 and 395 of the Indian Penal Code. Yes. The allegation as per the informant who has been examined as PW5 that on 9/7/89 around 3:30 p.m. the appellants, they more specifically, my lord, one accused was there, namely Jadumani Raut. This shows to what extent the case can become fabricated. Jadumani Raut, who was accused number 9, he chased the informant. Informant ran towards his village and entered into the house. It further alleged that Jadumani Raut was accompanied by 70 others. This Jadumani Raut was also placed on a trial along with others, and court found that suffering from leprosy, his 2 legs are not there and hands are not there.
Okay.
He chased.
Okay.
So he has been acquitted on, the court has observed there in the finding. Whatever it may be, court has disbelieved the entire prosecution case. My lord, I am drawing just some key paragraphs instead of going in detail. And let me see paragraph 6 of the judgment. 6.
Yes.
Before going to the judgment, my lord, I just want to say, charge has been framed against 70 persons for the offence under section 454 and 395. Well, let me see the charge, 49.
454, 395, yes.
My lord, charge is against 70 persons in this aspect. On 9/7/89 at about 3:30 p.m. at Mulagaon, so and so, committed house trespass in a building belonging to the informant Basanta Pradhan. House trespass. Then, after trespassing the house, they committed a dacoit. Court has disbelieved this 454. So we have not entered into the house. We have not broke open the house.
But convicted on 395.
395. Okay. I am drawing peculiarity in the case.
Para 6.
Para 6.
Yes. It is not deniable fact.
14 paragraphs. Judgment starts at page 14.
Paper book, first volume.
Well, I am just
para 22.
Page 22. It is not deniable fact that there exists hostility in between the accused persons and the PWs. The rivalry between the two groups, the case which pilot was pleased to dispose of on that day of Mr. Patnaik.
Yes.
The rivalry between the two groups, that is evidence from the evidence in the affair, where there is mention of an occurrence of 7/5/89, whereas the instant occurrence has taken place on 9/7/89. Add to it, all the PWs seems to be involved in ST number 327 of 90, and in other cases, besides the proceeding under 107 proceeding, is also sub judice between the PWs and the accused persons. According to PW1, his brother Nirakar and the son of Nirakar are also accused of this case. Similarly, 3 brothers-in-laws of PW11 through her husband are accused in this case. According to PW2, his brother Sarath is an accused of this case.
Past enmity.
So admittedly, past enmity is also there. Or is there, not also. Paragraph 8, see.
Yes.
Page 24, last 4.
According to PW 17.
Paragraph 8, after discussing last 4 lines of page 24. In these circumstances, the evidence of all the PWs read with the evidence of PWs 4 and...
Where are you reading?
Page 24, paragraph 8, last 4 lines, my lord.
It is not ascertained or at the top. It is not ascertained the PW.
In the circumstance, the evidence of all PW read with the evidence of PW 4 and 17 has suffered from suppression of facts and has undermined the credence of their evidence.
Yes.
Then my lord will see the discussion pertaining to the injuries sustained by the accused persons that court has categorically observed. Well, let me see in paragraph 9.
PW 17.
Has proved exhibits A, B, C, D, the medico legal, no, the logical कर दीजिए, medico legal report of accused Dhaneshwar Jana, Pavitra Jana, Managovinda Jana, and Srimati Jana. Exhibit A transpires that accused Dhaneshwar Jana had sustained lacerated injury on the occipital region of his head by hard and blunt impact. It was a bleeding injury by the time of examination by PW 13. The age of injury has been said to be 3 to 4 hours by the time of examination. Similarly, it transpires from Exhibit C that accused Managovinda Jana had sustained lacerated injury on the occipital region of his head by hard and blunt impact. It transpires from Exhibit D that Srimati Jana, wife of Parsuram Jana, seems to have sustained stab injury on the left elbow joint. The age of the injury is 3 to 4 hours. No one of the prosecution witnesses have explained these conspicuous injuries available on the person of these accused persons.
Accused persons also received injury.
There's the accused persons in the other case. There are two set of parties.
It refers to the accused person of other case.
No. How can it be?
I'll just explain. The exhibit number 4, 5, 7, 6, 9 and 8, Your Lordship.
No, let us see the exhibit A, B, C, D.
Who has exhibited it?
Here,
From the defense, Your Lordship. That was
From the side of the defense.
From the side of the defense.
Yes, because you have not explained the injuries.
Just come to page 44.
But let me be clear by the law. What is the...
Come to page 44.
Yes,
A, B, C, D. All these things are exhibited by the defense.
Yes, Lordship.
Defense.
Yes, Lordship.
And showing that they were injured.
They were injured.
Yes. Well, basic fundamental of criminal jurisprudence is prosecution is to prove its case beyond all reasonable doubt.
Right.
Except where the defense pleads exceptions, like right of private defense, like plea of alibi, like plea of insanity. There, the burden shifts to the defense, but not as rigor as prosecution. The preponderance of probabilities. Here, they projected a case not with clean hands. They suppressed how the occurrence has taken place and they tried to depict the occurrence the way they wanted to do. And they did it well. And they have suppressed the genesis of the case and they have not explained for which the court has categorically reached a conclusion. Prosecution have not explained the injuries available of the accused persons which has occurred at the place of occurrence.
Yes.
Let me see. Paragraph 9 also continuation. From amongst the PWs as evidence from exhibit 1 to 9, PWs received any cutting injury and what injuries they have sustained. They have sustained one bruise and abrasion. 70 persons assaulted, they entered into the house, they took one gunny bag of...
How many of them are injured?
Them? From that side, 2. From our side, 5.
7 persons are injured.
Seven injured. 7 bags.
Total 7.
Total 7.
Here,
the
7
informant had 2%. And
I'm coming to
the
that.
accused person 5%.
I'm coming to that. It has been stated so.
PW 3, 4, 5, 6, 7.
Even
and 10 are injured person from the side of the PW solution. From the side of the accused. From the side of the accused, it seems 1, 2, 3, 4.
Peculiarity is
there are 4 injured from the side of the accused.
4 injured
from the side of the accused.
4.
And 7 from the side of the informant.
allegation is specific that we were armed with different weapons, lethal weapons. My lord, you will see PW6 have sustained a simple injury on the head. PW4, who is the brother, stated to have one injury, that is
PW
six,
six,
four and
simple,
six.
huh? Simple.
Four, simple.
PW next.
Six simple on the head. PW5 and 7 stated to have received injuries, but PW3 did not find any injury on their person.
Hey, what is the nature of injury to 5 and 7?
Sorry, 4 and 5 and 7, no injury.
No injury.
My lord.
And PW3?
3 तक किसी नहीं.
No, who else?
PW3 did not find any injury on their person.
Who else then? He says seven people were injured.
PW3 exhibit number 5.
देखो ना दीजिए.
कौन इंजरी कौन तो?
देखो.
PW6 simple injury, PW5 and 7 no injury.
And my lord, the articles.
I'll place the PW13 doctor statement would be convenient.
You find out and tell me. The injured, who all are
there.
Yes.
The articles involved in the present case are, my lord, a pair of chucky, a long bench, armchair, 7 bags of paddy, 2 bags of boiled paddy.
There's a clash between Congress and Biju Janata Dal. That is the entire case of
And
the
454 has been disbelieved, and prosecution case has been totally disbelieved, but abruptly reached a conclusion. PW11 is the only independent witnesses. Here, my lord, initially,
where is the finding then?
My lord, finding that I have read, suddenly, my lord, he reached at a conclusion, my lord, like this. My lord, may see paragraph 20. PW11 is the only witness who is.
Para 13, just see para 13. That
13.
Jammu Moni story is para 13. As regards the initial changing of PW5 by
Page 20.
Jadumani.
Well, Jadumani, according to PW1, claimed to be the eyewitness, has stated Jadumani and Renuka threatened PW5 by Tenta, and they threw away the paddy of PW5. Whereafter PW5 ran away. According to PW2, he heard halla of PW5 that accused Jadumani was chasing PW5 by Tenta near his house, and also heard Jadumani and his wife threw the paddy. According to PW3, he found PW5 was coming from the house of Jadumani. According to 5, the person who was chased accused Jadumani, his wife and 2 others were sitting. Nothing is there. The concluding paragraph of PW13 is the injury reports proved by exhibit A, B, C, D, when taken into consideration mainly to this extent of the case together with the features discussed above, the version of the PWs seems to be filled with exaggeration and modulated statements. That is the finding.
Paragraph 16 would be relevant.
I'm confused.
Yes.
That is the concluding paragraph after considering all the metals on record. That's it transferred.
This is what the accused person took away 7 bags of paddy,
yes.
Boiled paddy, door leaf, 5 also 5 empty bags.
Paragraph 10, my lord, FIR has been lost against 71 accused persons, out of which Jadubani Raut is a leprosy patient, a deformed one. He chased. He first allegation is Jadubani. My lord, please laugh.
Jadumani Raut is a
leprosy
patient
and a deformed one. He seems to be unable to put his signature or LTI in the statement recorded under 313.
Sure, miracle happens.
Miracle happens in this way. All the PWs are threatened after the chase. So, my lord, I have drawn my lord's attention to 3 subtle positions of law, which is being referred to and relied in till date. That is, my lord, if a case where the witnesses and the accused persons are dragons drawn, or they are with inimical relationship, and they have suppressed the genesis of the case, what would be the duty of the court? And that should be the view. That is decided in, well, Lakshmi I must have relied upon.
Let us complete the MP order. You wanted to read, Madam, 16.
Para 16.
Let us read. It transfers from the evidence of PW3 that there is a commission of theft by the accused persons with respect of.
After looking at a finding that prosecution is full of exaggeration, modulated statements, this, that, then read it.
Page 30, Your Lordship, paragraph 16. It transpires from the evidence of PW3 that there was a commission of theft by the accused person in respect of 3 jewelry, a jonta, 4 flowers, a koda, a wooden box containing cash of ₹1,000 and 2 pairs of pant, shirt, and 4 pieces of sari. It transferred from the exhibit 33 that a theft of koda has not been reflected and there is a commission of 8 pakias. Read with the evidence of PW 17. He has not described the name of the accused person, Ramesan and Sonsu. Just before that, presently the appeal has been confined to, in the meanwhile, 2, 4, 7, and 10 hasn't died. So I confine my appeal to the appellant number 1, Monguli. In respect of Monguli, PW 1, 2, and 11.
Who died, you said?
2, 4, 7, 9.
1 minute, I'm no it down.
2, 4.
8 minutes. Who died? 2,
4.
2, 4.
7.
7.
And 10.
10.
10.
Died, huh?
Yes, sir.
Died.
So now the appeal confined to 1, 3, 5, 6, 8, and 10. Appellant number 1 is Mongoli. In respect of him, PW 1, 2, and 11, they state the specific role played by this accused. In respect of appellant number 3, Porsunam, PW number 1, 5, 6, 7, 8, 10.
For Mongolu, PW?
1, 2, and 11.
1, 2,
and 11.
Yes.
And PW, appellant number 3, Porsunam.
PW?
1, 5.
1, 5, and?
6, 7.
6, 7.
8, 10, 11, and 16.
8, 10, 11.
And 16.
16, yes.
Thereafter, appellant number 5, Benudhara. Star in respect of 1, 5, 6.
Yes.
9, 11, and 16. Should I indicate the right paragraphs?
No, 6.
16, Your Lordship. 11 and 6. Then 6, Your Lordship. Ashok Pradha.
16 and?
16. That's
Only
right.
16.
16 is the informant and he almost.
Yes. What about 8?
Your Lordship, thereafter, appellant number 6, Ashok Pradhan.
Ashok Pradhan, I have done it.
Ashok Pradhan is 5, 6, 7.
And you said 5? Benudhara?
Appellant number 5. I was telling the appellant number 5.
Only 16.
No, only 6. 1, 5, 6, 9, 11.
Then Ashok Pradhan 6.
6 and 5, 6, 7, 9, 11, 12, and 16.
And
thereafter, Paramananda Das, his accused number, appellant number 8, 8, 11.
8 and 11.
8 and 11.
Yes.
Thereafter, Rabindra Kumar Samal. PW, appellant number 10. The PWs are 2, 3, 8, 9, 11, and 16.
8, 9, 16, huh?
They
have deposed regarding the
role played by the particular accused persons.
What is the role played according to you?
I'll just place it.
Part of which was not believed.
Part of us not believed.
Then
I'll just place the record.
If they have not trespassed the house, where from they have stolen the? It was lying outside.
No, lying
the
in the
PD and all.
Lordship, there is ସେମାନେ କହୁଛନ୍ତି ତାଙ୍କ ଘରଟା ଗୋଟେ ଖଞ୍ଜା ଭଳିଆ ଖଞ୍ଜାରେ ଆଜ୍ଞା ଡୋର ନଥିବ ଖଞ୍ଜା I'm not presuming.
After you disbelieve the story
454
to the extent of 454 saying that they have not trespassed the house.
Yes,
Then where is the, how do you believe the dacoity part? And the dacoity is done, the picked up the things which were lying inside the house.
No. House is never, the particular term house is never used.
Where from you derive that?
No, I'll just read the 395. I'll just read the 395.
Or a dwelling house, the PW 11.
Yes.
Bishop, I'll place the robbery so that that is just the aggravated form. डकैती करते तो घरटा important नुहे बिल्कुल important is the,
How can my non-friend says you charge is 450?
that 454 was gone.
Gone. See, the story is they came, all 70 people entered inside the house and stolen the things. This is the story.
Yes,
And in so far as the first part is concerned, the court says no.
454
Not
that is not
true.
I'll just place
Because the
390.
second part is in a continuation of the first one.
I'm conscious.
And later complete the 394.
I guess independent witness witness.
ଘରକୁ ପଶିଲେ ବୁଝିଲେ ନେଲେ ସବୁ ସେ କଲେ ଘର କବାଟଟା ଭାଙ୍ଗିଗଲା ଡିସବିଲିଟି ହେଇଗଲା ତାହେଲେ ଘରକୁ ପଶିଲେ କେତେବେଳେ କଲେ
PW 11.
ingredients what
PW.
the occurrence took place about 1 year and 9 months back. That is at place 676.
PW 11 is the your star witness.
Court said star witness.
The star witness is Basant Pradhan, PW 16.
Okay, let us see 16 also. Let us read 16 also, no problem. Yes, read it, madam.
The occurrence took place 1 year and 9 months back. 11. The occurrence took place about 1 year and 9 months back at 3:30 p.m. I was in my house with my son. Some people knocked my door. I opened the door. Accused persons, namely Ashok Pradhan, Bhatta Pradhan, Patti Bhola, Monguli Bhola, Jagir Bhola, Chaitanya Bhola, Rabindra Samal, Narendra Samal, Parsuram Jena, Abhiram Jena, Ramesh Pradhan, Sarat Pradhan, Pada Naik, Bamadev Swai, Paramananda Das, Benudhara Pradhan, and some other whom I could not identify entered into my house.
He identified entire village.
So I can't improvise on fact.
Yes.
They were armed with Badi, Bahungi, and Farsa. On my protest, the above named accused persons threatened me to rape. They further threatened me to kill my son by cutting into pieces. Out of fear, I stood in a corner of the room. They broke the door and window of my house. They took away 2 bags of boiled rice, 2 bags of paddy seedlings, 2 bags of rice.
They broke the door. This is important. They broke the door
They
and
broke
window of the house.
Yes, Lord.
And they took.
They took away the. Yes, sir. There are articles they have mentioned.
All the articles.
Yes.
Okay. Articles. Yes. Yes.
Thereafter, in cross-examination, and she just from the in paragraph 2, your lordship, in cross-examination, our khonja. That is what I was impressing upon your lordship. It's a consistent case of all the people. They live in a khonja. The khonja gote hi entrance to छोटे rooms surrounding ही कितना. Our khonja consists of 4 rooms. There are 2 rooms in northern side of our khonja and other 2 rooms are in the southern side of our khonja. There is one front door to the west side. So there is another door which is on the northwestern room occupied by Rabindra. We stay in the northern eastern room. Narendra stays in the southern southwestern room. The southern this is the this is how the khonja is placed, your lordship. ସମସ୍ତେ exist saying ରୁହନ୍ତି but door in the particular in 395 I'll just summon ki particular ଘର ଭିତରେ ପଶିକି କରିବାଟା 395 may not be confined to that. And I'll place, if your lordship, I've just indicated the particular PWs. They state the particular role played by the present appellant, and they have been armed with weapons, your lordship, and there are 5 more than 5 of numbers, your lordship. I'll just place the robbery, the definition of robbery.
Continue that page.
Yes, lordship.
678.
678, your lordship.
I had not locked the
I had not
door of my room.
Your lordship.
When
had
I
opened the
came,
northern side door, which
in
was in
spite of
Ravindra's.
that,
I had not locked my door.
they broke open the door.
Yes, ma'am.
They
They
broke the
that
door
by
by
means of
means
body
of a body,
become pieces.
and it was become pieces.
Cannot say if the
I
door
cannot
is
say
open
that
till
the
now.
door of the opening is still so and so. I broke which doors. Like
Similarly, the accused person took away the windows and door.
these doors broken.
I'm not in my house since the date of
They
appearance.
broke one window. Similarly, the accused persons took away the window and door loose and since the occurrence. Yes. Yes.
Shiva, I'll presently the conviction is under section 395, which is the aggravated form of the robbery. I'll place the definition of robbery and I'll indicate the role attributed to the present appellants. That will suffice to the
But which part? Let us see the how the trial court disbelieves 452.
454.
Let us see what does it say. Which part?
Half of the PWs are discarded only because they are related to each other.
Page 39. The occurrence is of 1989. PW1 has deposed in the court on such day. The ratio of the citation so and so. The slight addition of commission of testimony of PW1 cannot be affect her credibility. According to PW1, she opened the door for mere knock.
The court held that the
Ready.
slight
And
addition and omission in the
as
testimony of PW11
PW cannot be
cannot be
said to have been
substantiated, nevertheless.
sustained against these accused persons or the house. But nevertheless,
451 ହେଲାନି କିନ୍ତୁ ଏମାନେ ଘରେ ବସିଥିଲେ ଲସ୍ ବାହାର କରିଦିଆ LCM GCA ପଢାଏ
313 statement to ସମସ୍ତଙ୍କର concluding ହଉଛି
mentioned house did commit theft. Read that last part. Last part of the here.
yes, sir.
39 paragraph.
Uh,
According to PW1 in middle. According to PW1, she
11.
opened the door
According to PW11, she opened the door
on mere knock.
on mere knock.
Thus, the
offense under section 454 IPC cannot be said to have been substantiated against these accused persons involving the house of PW11. But nevertheless, the independent character of the evidence of PW11 accused Rabindra Samal, Ashok Pradhan, Bhatta Pradhan, Patti Bhola, Mongoli Bhola, Jagir Bhola, Parsuram Jena, Padda Naik, Paramananda Das, Benudhara Pradhan can be very well said to have entered inside the house of PW11 and did committed the theft of her belongings by putting her into the instant fear before the commission of theft. Thus, in the net result, the prosecution...
They have entered inside the house.
Yes, Sir. Not only the PW11, there are other PWs against whom the offense has been committed. Your Worship. Thus, in the net result, the prosecution has not been able to substantiate its case against any of the accused persons conclusively for the offense of 454 IPC.
Because these names were taken, these Ravindra Samal, Ashok Pradhan, Bhatta Pradhan, Yes, ठीक है.
That is regarding 395. The court is relied upon the 395. Disbelieved the 454 in what comes to.
And then see the 395. See 354 is disbelieved by disbelieving PW 11.
11. They have confined in respect of PW. You say
Only on the basis of PW 11.
11.
The entire story is disbelieved.
Disbelieved. Just because she said that upon knock she has opened the door.
But this is a case like this. It is up to the appreciation of the admittedly, which my knowledge friend will also admit. Admittedly, there is a faction in the village, two groups. Two cases have been registered. In one case, the accused persons are witnesses in the other case, and the witnesses in the other case are accused persons in this case. We have made an allegation against them, for they have been convicted under 380, and because our numbers are both, we have been convicted for 390.
सेठे के बेसिक किसी नहीं पालन किसी टीन बॉक्स से का नहीं.
So, admittedly, NDP is there. Court has also reached a conclusion that is strong in the university between the two groups. At this juncture, law regulated this quick matter. If witnesses are evidence not be thrown away as it is, but in well corroboration. Who has believed evidence of all witnesses and upon PW 11. PW 11 also says about 6 finding. Similarly, 3 robbery law of PW 11 who were confined and accused in this case. He is also interested for the prosecution. But he is also interested for the prosecution. His evidence has been disbelieved in part. But our evidence has been disbelieved in part. No other independent witnesses are available. We rely upon the authority.
It's not safe to rely on that kind of a
4614, where the Hon'Ble Apex Court has categorized 3 types of witnesses are there. Only reliable, only unreliable, part reliable, part unreliable, complete unreliable. And those are today. That is the specific which will help in work. Witnesses in the background of facility when the witnesses are talking to examine to prove against the person. Definitely they will say so. Process of forgetting, if they could have said yes, advantage has between us and we have received even if they are not received results. That they have stated the truth. They have stated that we have entered in the house, we communicate the ID, we have taken this.
The injury received by you is not explained.
It is very important as per this because injuries are the vital part of the body. Well, the last occasion I was drawing pilot Hutchinson, his husband, which I had used long back when in 1992. And secondly, almost just complete. Let's see. 1925 was share. 529. And as I see, well, finally, yes, having this piece of order government. And actually, it was a single degree. Then you find that it will find a sustainable injury. It cannot be laid down as a general population. That whenever there is an injury, an accused, which is explained in the first reason, that we just don't want to say where there is level, The solution of for an explanation regarding the increase how the accused it may show that the evidence is that the incident are true or in there are only true. This claim has been expressed by the Supreme Court to notorize and not the yes, sir. Not the English, the accused by the prosecution have failed prosecution, there is a 76 improvement to the 16. And in our
Trustworthiness of that witness can be doubted by the court. I think that is not explained, that's last part. Last part is there.
in case and I had one incentive to happen to happen to this area. Each below the middle of the right shoulder. The same was simple in nature. I was able to put a new code. It was not a council of state was specific and not that type of occurrence. Even when the hospital, the teacher 3 or 3 4 hours in 4 hours old. And then 5% of the state injuries and the resilience not.
They don't believe them.
Take up 76, put to 6 things, we can take a lot of it, paper share, and also by the 57 Supreme Court, where this is the best laws I have ever seen. We are not out of the yeah, we can mistake it. Generally, speaking, CORAM basically in the text may be classified into 3 categories, namely only reliable, only reliable, either only reliable, not only unreliable. In the first, the difficulty of proof, proof could have no difficulty in coming to its conclusion. Either way, it may convict or may if it is found to be approach. Or suspicion of interested males incompetence or sovereignty. The second category, the whole equality has no difficulty in coming to its conclusion. It is the third category of process where the court has to circumspect and to look for collaboration. In that particular, by the time of testimony, direct the circumstances and the another testimony insisting on plurality of witnesses irrespective of equality in terms. Yes.
Yes, I understand. Yes, madam, now you have to answer one thing. If PW1, actually PW11, is believed to the extent that the has narration of the stories insofar as 452 is not believable. And the fact that she has not explained the injury sustained by the accused persons, or he is not even told in her examination. If he was duty of not opening to her, tell the truth. So in those 2 counts, if the can be believed. Because of this judgment is directly shows if the accused sustained injury, the prosecution witness has to be honest enough to say that he has sustained injury. Cannot explain how injury is sustained by him, but on the occurrence, he has sustained injury. But PW11 doesn't say anything.
Maybe explain the suspense of the injury, maybe
That is expect. Explanation of the injury is one.
Yes, Mr.
And
And
injury
yes,
cause, the very fact that the injury is caused, you have to telling the.
There has to be a link between the injury and the occurrence. Before that, that.
Then you are explaining, injury is caused somewhere else.
That has to be a loss. I'll just place the.
How can you do that? Where from you get?
There is nothing on before the search is there.
Where from you get it? I asked you, what are the places to do when sustain injury? You tell me. PW6, you say simple injuries.
PW3, 5, 6, 7, 10, and 16 are the injured persons.
7,
10, 11, 10, and 16.
and 16.
Okay, injured persons.
As they said, any of one of them has said that yes, the accused persons have also sustained injury.
Say that they have been assaulted by the accused persons, but they never say that they have been retracted back. But this is not the case with the prosecution.
Right. The four injuries are hitting where? The four.
None of the suggestions.
Paragraph injury.
There.
For 9, huh? Judgment reduce. For 9, for 9. And PW para 9 movement. PW 17.
W13 is the doctor. 17 is the.
Yes. In the unexplained injury thing, you are relying upon 1992.
Qualified to share.
Qualified, sir, okay.
76 report 263. They have managed the access of the
And the Supreme Court
ruled as of last week versus state of Bihar.
63.
Actually, distinguishable. That is a case of murder, that is a case of private defense. So that, looking 1976 to 60, that is a case of murder.
You tell me the witness, since then erase the name of, remember the name of Adrian is 13 people, but he doesn't remember the fact that they have also.
This,
He narrates as if he knows the first name with the title.
it's not the case of the prosecution that they have been assaulted and they have retracted back, by which they have the accused person of sustained injury. So he explaining injury does not arise first, and nothing, you should know cross-examination, there is no suggestion to that effect that the accused person of sustained injury by the prosecution is necessary.
If you are written what if you want.
And the 1976 Supreme Court was actually this one. There are no corroborating witnesses, there are no eyewitnesses. I'll just place the last para for a 1976, which was
Yes. Lakshmi Singh you are talking about.
Lakshmi Singh.
Yes.
There are three, this is the case of 395, there are eyewitnesses there, injured eyewitnesses are there, and the incidents of 395 are well made out.
Keep it working. Important.
Well, your lordship. In this case, the appellant is convicted under 26I of NDPS Act and was punished for years of dismissal imprisonment and 2,000 fine, and is alleged to have been carrying 3 kilos of contraband ganja. There are 3 witnesses here watching. PW1 being Constable Ramchandra Sethi, PW2 being ASI Lakshmidhar Lenka, and PW3 being SI of Excise Vigilance Department, Jayant Kumar Bakshi. They have claimed to have got the reposition of one independent business, but he has turned hostile, your lordship. He has deposed that that he did not see anything in the hands of the accused, that the excise officer did not show him any ganja that has been recovered from the accused. No other witness signature was procured in his presence. He also says that the seizure list was not prepared before him, and neither was he read over and explained the content of the election.
Who turned inside then?
PW1 election. He's a witness.
PW1.
PW1. He's a witness.
Who examined him?
Yes, Your Lordship.
Then why, let's say, time then?
Not hostile, Your Lordship. There are no independent witnesses. Your Lordship, there are also a lot of contradictions in their statement as well. May I take Your Lordship's for part 14 of PW3.
The three guy.
I hope, Your Lordship. In para 14, the PW3 has proposed that the sample ganja packets was preserved in the Malkhana of his office, and he was in charge of the Malkhana. But in PW3, but in paragraph 2 of the same provision, he has said that he forwarded the sample as well as the seized contraband along with the accused person. But in the order sheet, Your Lordship, he has only forwarded the accused person along with the serial list, Your Lordship.
What does he say?
Said that he forwarded the seized article as well as the accused person on the same date, Your Lordship. But the sample and the seized article was
the samples to the CFS.
No, Your Lordship, FDG information. But Your Lordship, in the order sheet, it is mentioned that only the serial list was forwarded along with the accused person, not the contraband. No. And the contraband was in his possession. Start with PW1, please.
PW1. Let me read it. Let me do when we have the phone. Yes.
Your Lordship, statement of PW1 is as thank you. I was an excise constable, Vignesh. On that day, I, along with our SI, J.K. Bakshi, ASI Lakshmidhar Lekha, had been to Old Town, Vignesh, on patrol duty. While performing duty at Adhagori Chowk, we found this accused was proceeding towards Sibo Sankar, carrying a bag in his hand. On suspicion, our above named SI detained the accused. Then the SI procured attendance of independent witnesses, namely Vidya Behra and Kailash Chandra Mohanty. Then the SI expressed his intention to take search of the accused, and after the SI officials, Kailash Mohanty is examined, Your Lordship. Yes, Your Lordship. Yes, Your Lordship.
Yes.
Vidya Behra has not been examined. On search, witness in presence of the accused, the SI took search of the accused. On search, ganja in a polythene packet was recovered from that handbag which was being carried by the accused. The SI took weight of the recovered ganja by means of the weight instruments carried by us, and the weight of the ganja became 3 kgs. The SI seized the recovered ganja along with that handbag and prepared a seizure list in presence of the witnesses, on which we signed. Exhibit 1 is the seizure list, and where exhibit 1 by 1 is my signature. The SI drew sample of 35 grams from the recovered ganja, taking weighment for the purpose of chemical examination. The SI sealed that sample ganja packet as well as the rest of the recovered ganja after keeping the same in the handbag.
Chemical examination report is placed on record.
Yes, Your Lordship. Yes.
Exhibit.
Exhibit. Just a minute.
Exhibit 3, Your Lordship.
Exhibit 3. Okay, proceed. Yes.
From the smell, color, and size of the recovered materials, as well as from its smell and from my experience as an excise official, I was able to know that the said material was ganja. A copy of the seizure list was handed over by the SI to the accused, and in token thereof, he gave his endorsement with signature on the reverse of the seizure list in our presence. Exhibit 1 and 2 is his said endorsement with signatures. After such seizure, we returned to our office along with accused and the seizure articles.
Yes.
PW.
Right on. 4. MO1 is the handbag. And
Yes, Your
MO2 is the
Sealed polythene packet.
Yes.
Your Lordship, can I take Your Lordships to PW3 statement?
PW3 now. Okay. Yes. PW3. Yes.
Your Lordship, PW3 here has also stated in para 12 that before taking search of the accused, I asked if he wanted to be searched before a magistrate or gazetted officer, but he told that he did not want to be searched in presence of any of them and may be searched by me. I have not mentioned these facts in the prosecution report. In presence of the in presence of the witnesses, I had given the option to the accused. But the witness has also denied that in his presence, the accused person was not searched. And he is not a gazetted officer, Your Lordship. I have been in non-compliance with section 50, Your Lordships.
Yes. Yes.
And under section 52C, Your Lordship,
Come to section 50. Section 50. Come to section 50.
Yes, Your Lordship.
Ready?
Conditions under which search of persons shall be conducted. When any officer duly authorized under section 42 is about to search any person under the provisions of section 41, section 42, or section 43, he shall, if such person so requires, take such person without unnecessary delay to the nearest gazetted officer of any of the department mentioned in section 42 to the nearest magistrate.
Yes.
2. If such requisition is made, the officer may detain the person until he can bring him before the gazetted officer or the magistrate referred to in subsection 1.
Further.
3. The gazetted officer or the magistrate before whom any such person is brought shall, if he sees no reasonable ground for search, forthwith discharge the person, but otherwise shall direct the search be made. No female shall be searched by anyone excepting a female.
5. Read 5. Hold on. When the incident happened?
1990, Your Lordship. 16 to
90.
19. 16 to 19.
Okay. Hold it. Yes. 5 is not right, okay. Okay.
Your Lordship.
First point is by reading PW3, para 12.
Yes, sir.
You say that there is no compliance of section 50.
Yes, Your Lordship.
Yes. Yes, next point.
When there is a,
Let her complete her point. First point is this. Yes, next.
Your Lordship, second point is.
Second point is no independent witnesses were examined.
Yes.
So both the witnesses were present. That is reflecting from PW1 statement.
Yes.
Rather, one of them, that is Kailas, has been examined by you.
Yes.
Who says that I have not seen anything. Kailas examined by you.
Yes, sir.
Hmm.
Your Lordship, another section is 52, where the gazetted officer is supposed to take the permission of the magistrate before drawing any sample. Considering that he is not a gazetted officer, Your Lordship, he drew the sample on spot without again saying that he procured the witness, procured the signature of the witness, but then he did not produce that sample in front of any other officer, Your Lordship.
Yes.
Then in PW3 statement, in PW3 statement, paragraph 3,
Yes.
states that on 5/3/1990, he forwarded the seized sample of ganja packet, putting it in another seized packet to the chemical examiner. I had personally carried the sample packet and delivered the same, and that seize the packet of ganja that he seized, or the sample packet drawn from that contraband. He kept it with a paper seal in his malkhana for about 17 days. Your Lordship.
Para 3 approved, PW.
Your Lordship, may I please show Your Lordship the judgment regarding them?
Yes.
2019-75 OCR 761.
Give that. Yes.
Your Lordship,
In this regard,
yes, Your Lordship.
the sample was not in the malkhana and kept there for
No, Your Lordship. Regarding the brass seal, Your Lordship.
brass. Yes.
Your Lordship, in that paragraph 8, it is mentioned that neither brass seal nor special seal produced in court at the time of the production or seized articles. Provision of section 57 of NDPS Act was not complied. And hence, in this case, Your Lordship, the conviction was reversed and he was acquitted.
Which paragraph? Para?
Yeah, Placidum A, Your Lordship. Placidum A.
Just see the para. Placidum what? Para 14, come to para 14. Come to para 14.
Yes, Your Lordship.
Read it. Read it.
In the present case, when the independent witness has not supported the prosecution case, the version of the two official witnesses like PW2 and PW3 are contradictory to each other, and the version of PW3, who is an important witness for the prosecution, is full of ambiguities. The brass seal stated to have been given in the Zimma of PW2 or the specimen seal impression was not produced before the court at the time of production of the seized articles. The provisions under section 57 of the NDPS Act has not been complied with, and moreover, when PW3, being the officer who not only carried out the search and seizure, but also conducted the investigation and submitted the prosecution report, I am of the humble view that it cannot be said that the prosecution has fully established the charge under section 20B2C of the NDPS Act beyond all reasonable doubt against the appellant, and therefore the impugned judgment and the order of conviction cannot be sustained in the eye of law.
Yes, yes. Proceed.
Your Lordship, I have another.
These are the 4 points you have.
Yes, Your Lordship.
Yes, madam, you answer.
This is
He
the violation.
says 50,
Yes, sir.
52, 57 not complied. Independent witness, though named, you have not examined. Rather, one of them she examines
Examined.
and
he has
he
supported the
supports the
prosecution.
case of yes.
CW 1, 2, 3, that the official witnesses as well as they have completely supported the prosecution story and may I read the relevant paragraphs. I'll just place the CW 1 for
You answer it whether 50 is complied.
The 50 need not be complied with, but 50 when it comes to the personal seizure and search and seizure, then only the option regarding the guest
What about
officer of
52 and 57?
52 is not authorized in your Lordship. That is a notification has been exhibited. This is not the part of the record. That has to be seen in that regarding.
Exhibited.
Yes, sir.
Where is that?
An exhibit.
Exhibit list.
That was exhibit 4 and 5.
Exhibit 4 and
Exhibit 4 and 5. That is a notification 1 under 4267 of the NDPS Act and the copy of the notification is in 53 of the NDPS Act. That might be the authorization.
50 of the LCR. Page 50 of the LCR, that is exhibit.
50, yes. Exhibit.
It gives power to the SI of the Excise Department of the OIC of the local administration.
Exercise of power of section 1 of section 42.
The authorization is there.
Okay. Exhibit. What this is exhibit 4.
May I please, Your Lordship? The authorization under that notification is to seize and seal the articles, seized articles, Your Lordship, not to personally search anyone.
Where is the language is?
Let's see. I don't require to be a guested of.
No, language is see. Section 42 and 57 are do so and so, so and so. The state government do hereby empower another officer and of sub-inspector of excise, State Department of States,
Section 50% civility more better than
Your Lordship, I have a judgment regarding that.
and the section 42 comply, huh? Yes.
Regarding section 50, Your Lordship.
Okay.
Section 50 relates to the condition of the purse of persons, search of persons, Your Lordship. It is a person search and the bag search. There is a difference.
1 minute, let me note down. I thought it is a small case. I started writing in a small sheet. It appears to be as note down. Petitioner's point general. Number feed about 68 of 96. Yes. It is.
There may not be any infraction of section 50 or the 42 or anything. But she might have a case for sampling and the seal and everything.
Yes. Yes. What do you want to show?
Your Lordship, may I kindly see paragraph 1 of the
Paragraph?
judgment. The first placitum, Your Lordship.
Yes.
It is an imperative requirement on the part of the officer intending to search to inform the person to be searched of his right that if he so chooses, he will be searched in the presence of a gazetted officer or a magistrate. Failure to inform the person to be searched, and if such person so requires, failure to take him to the gazetted officer or magistrate would amount to non-compliance of section 50, which is mandatory, as thus it would affect the prosecution case and vitiate the trial. Your Lordship, in paragraph 12 of PW3, he says that he asked this question to the accused person in presence of the witness, which the witness has denied. But he also mentions that I did not mention those facts in the prosecution report.
My submission is section 50 does not apply at all. Section 50 applicable when the search of person is conducted, not to his belongings.
You tell which point he has you agree with.
That the sealing part, Your Lordship.
57.
57.
Then that is one point
That is
entitled for it.
Yes, I'll just
57 is they directly covered by this judgment.
they don't have a case under section
Justice
50
Sahu's
or
judgment.
52. Yes.
Let us concentrate in one point where she can succeed.
Yes.
Need not deliberate upon all the points.
No, in fact, I'll confine to
57.
57.
Do you have any answer to that?
I'll just
2019 75 OCR.
She has given me a copy. Thanks. Because no brass seal or anything regarding the Malkhana has been exhibited. That's
Nothing.
That has not been exhibited. Yes.
Seven of that old act. The sample should be drawn before the magistrate. In place of the magistrate.
Old act, old act.
I have that.
Now they give it. Give old. All the matters are from old years, right? So 57 you have a case. That's what she also says, but she will just search it out and tell me if you can add something. Okay. I will concentrate on 57 only.
57
only. But other things, there is an answer to that.
51
Here also applies.
No, 50 won't apply.
But 57 is apparent.
57 is on the face of it. That
Apparent. So let us consider on 57. What is the age of this man?
64 years.
64 now.
Yes.
Undergone period in undergone.
It is not evident in the LCR, Your Lordship.
And say that part is wrong.
What is your name, madam?
Upasika Samantray, Your Lordship. Upasika Samantray.
Sika
Samantray.
Sika Samantray. Along with
M. Faradish, Your Lordship.
Appearance, Mr. Judgment is your call. If you want to give in writing, you can give. I'll just give 1 week time.
Yes, Your Lordship.
Argument her. The parties are at liberty to file their written note of submission within a week.
Yes, Your Lordship.
I'll just reply in respect of the sealing.
Yes.
And regarding section 50 and the other thing, I just submitted that doesn't applicable to this case when it.
You just give a note.
Yes.
Yes. Item 14.
Obliged.
Lordship, in this case, initially the appellant faced trial under section for the offences committed under section 376 and 31 of SCST Act. There are
Whether stayed in custody for 18 days.
18 days. What is the sentence about it?
Sentence is 6 months, my lords, for the offense under
Offense?
T20.
See? 23.
6 months for 148, 323, and 149 minutes.
How many of you are there?
6 are there, my lords. Out of 6, 1, 2,
10 were there.
6 are with us in the present appeal.
323, huh?
323. Allegation is that there was a procession of a DT going on in the road, my lords, wherein there is a tradition of the local Adivasis to bring out weapons like swords, iron rods, and all of this. This is admitted by the IO in the examination also. And they bring it down and they obstruct the procession of the DT, in which there is a bargain called out, and in respect of the bargain, liquor or some other sort of pleasement is offered to the people who have blocked the DT's procession. During this period, Milos, there was an altercation, because of which the present FIR was registered against these 10-15 people.
What are the injuries?
320.
Who all are the injured?
PW4 is the home guard, is the injured. PW9 is the IU as well as the informant in this case.
Oh, who is injured?
PW4, home guard.
Doctor?
PW8.
PW8 is the doctor, who was examined the injured.
PW5 is the eyewitness.
PW3 is the injured. All the accused persons then assaulted PW3.
1, 3 are police.
1, 3, 4. They're injured.
1, 3, and 4 minutes. 5 is the eyewitness. 2 is the Havildar. 10 is the ASI. 6 and 7 are witness to the seizure. 8 is the doctor.
Nanu, Ganesh, Sadhu, Zantu, and others.
The FIR states, the FIR which has been registered with the IAC, states as per tradition of Adivasis, the villagers of Isagaon, armed with lathis, swords, iron rods, blocked the way of Buddharaja to get some tips like liquor, etc. Some Adivasis of Asagaon who were in violent mood to create breach of peace. It's a situation wherein, Milords, violence is bound to happen.
Place the
All injuries sustained by them are simple in nature.
simple in nature, Your Lordship. Your Lordship, may kindly appreciate. PW1, 3 were the persons who were in charge of the law and order. They were there to protect the witnesses as well as the village.
They are the
persons.
police.
And they have been assaulted. I'll place the. Can I
They are the
say-
police. They are the police
The
personnel.
situation
Yes,
wherein the tradition and the
That
profession
does give you a
demand-
license to assault the police officer.
And that's entirely correct. But it's a situation where
License is otherwise. Yeah.
it's a situation where all these people, it's as per tradition and custom, they are armed with lathis, swords, iron rods. This is the FIR drawn by the IAC himself.
You should kindly see the statement of PW1 and
Yes.
the manner they have.
Para 2, I'm reading that. Yes. On 13/10/96.
May I- On 13/10/19 mobile file. On 13/10/1996, I was on duty at village Igan during Dengi Sargi festival to maintain law and order along with the other police staffs. That day at about 5 p.m., a person armed with brick at Chhatra of deity Buddha Raja of Singh Akela during the ceremonial procession. There was a commotion and police constable number 204 Amulya Kumar Bal is one of the injured also. Went there to pacify the situation. Accused persons assaulted him and made him lie on the ground. He was assaulted with lathi and iron rod. Accused persons while assaulting were shouting. Kindly see the abusive language.
Has he taken the name of anyone?
Yes, sir. Pardon.
Has he taken the name of any accused?
Just
Because there are many procession was going on.
yes, sir.
Maybe hundreds of people
Yes.
who is very name.
He has not mentioned any name.
Then how will you nail down these accused persons?
There were around 40 people.
And come to PW2. Has he taken the name? How many accused are put to
10.
trial?
10.
10. Out of them?
6 were convicted.
Once he says that accused person have assaulted,
Yes.
all of them should have been convicted.
My problem here, half of the judgment is not there in the Vakam. From page 12.
That's not your problem. Your problem here also.
And I don't have a brief, so I'm relying upon your lordship.
The PW2.
Yes.
See, he says PW2 in the second paragraph, he says, I ascertain that accused Nanu so-and-so was armed with lathi and other accused persons with iron and lathi rods assaulted the injured persons.
The PW3 has stated.
He doesn't say PW2. I'm talking.
PW3, your lordship.
No, PW2 is also injured.
Also injured.
But he says what he says. Just see.
Yes. PW3 first.
Yes.
I know the accused persons were the village Eagle. On 13/10/1996, I was police constable attached to so-and-so on that day at about 5 p.m. while I was on duty of maintaining law and order village Eagle during Dengi Sargi Yatra. When I restrained accused Nanu Bhagati, he has named particularly Nanu Bhagati from dismantling the Chhatra of deity. Sunny accused Akshay Bhagati from back assaulted with lathi on my back. After assaulting, when the accused Akshay Bag ran away, I chased him. Accused person namely Nanu, Ganesh, Sadhu, Juantu and others chased me, and when I fell down, they pressed my neck against the ground and assaulted me by lathi and iron. Accused
So then Nanu, Ganesh, Sadhu and Akshay.
And Juantu.
Juantu. Just see who are they?
No, Ganesh is here before my lord. And Sadhu is here before my lords. Ganesh and Sadhu are 5 and 6.
Ganesh, Sadhu. And who else?
Others aren't even convicted.
Where have they gone?
Akshay is appellant number 1.
Hmm?
Ugre Jihatu Manu Bhagati, Ganesh Behera is accused appellant number 5.
Sadhu.
Sadhu is Sadhu is 6.
Nanu.
Nanu is not.
But that is the only evidence. PW3. That is not even corroborated by other injured. This person he had been assaulted.
Examination also, PW3 in paragraph number 5. Yes. Reiterated the same thing. The accused, namely Ganesh, Sadhu, Juantu, Nanu, and many of others also pressed me into against the ground. When I fell down, I cannot say the who assaulted which part of my body.
Nothing is there.
The injuries are.
He takes the name of 5 people.
5.
Punga Tripathi had injury on his leg. But
And selectively you have chosen couple of them and left couple of them.
This is the IAC who's written the FIR, and these are the constable, these officers who have given the position.
Can I check the impugned judgment first?
Is there in the
It's
FIR
not.
also? What's in the judgment additional session?
Paragraph 12.
The incident taken place somewhere in the 96.
October 96. 96.
PW4 has named the accused persons. PW3 and PW4, they have named the accused persons and stated out the specific role played by the accused person as well as the weapon of offense they have carried.
PW4.
PW3 have just placed. PW4, the paragraph number 2. May I read? On 13/96 at about 5 p.m. while I was on duty to maintain law and order at village Isa during Deng Sargi Yatra, accused Akhyaba assaulted PW3 by a rod. As a result, he failed out. All the accused persons then assaulted PW3. When I myself, homeguard Devarshan and PW1 went to the rescue of the PW3, accused Akhyaba with iron rod assaulted forehead of PW1. As a result, he fell down on the accused person. So, at shouting, one of the accused persons with lathi assaulted my right
He is not taken the name.
Yeah, named Akhyaba.
Before that,
Only Akhay.
Mention means that all the accused persons then assaulted PW3.
Okay, but he has named one of the accused persons and role attributed to him.
Then let me kindly see his
He says Akhay assaulted in the forehead of PW1. But where PW1 says?
PW1 says the assault made by the accused, he has not named him.
Then
let me kindly see PW1 in this context. PW1 states, end of his deposition first page. When I came to rescue Shri Barik, accused Gentu Bag assaulted my forehead with iron rod. The separate person. I felt senseless. Not Akhay Bag.
Next page to accused
Akhay Bag
assaulted my right hand.
Right hand, but no, so let's stop. Then PW4 is stating that Akhay Bag assaulted on his forehead.
There might be some discrepancy. PW5 also he has named certain accused persons.
Material control.
PW5 is chief, he says, first flow I warded off and second flow with iron rod. Head of PW1, MO1 is the iron rod which.
He does not state anyone's name. He states, I was also assaulted on my intervention. First, I warded off. Second blow with iron rod struck.
Continue.
Head of PW1.
Continue.
MO1 is the iron rod. Jintu Bag assaulted with rod. PW.
4 was assaulted
Yeah,
on his
MO1
right.
is the assault. PW4 was
He
assault.
has named Jantu Bag.
This is a crowd fight, And these testimonies of all these officers are not entirely consistent with each other.
From the appellant number 1, there is seizure of stick, Your Worship. Exhibit 3 is the evidence, and the MO1 is the stick.
The possession where everyone is armed with deadly weapons.
see, how can you bring 147 or 148? There was no common intention. The procession is going on. They have not assembled with a common intention to do anything.
जो लाइन टा कहिचंते जे पुलिस माननको मारो with abusive
But
language, that must have
that
been
happened instantly there when the procession was going on.
ଜଣକୁ assault ହେଇଥିଲେ instantive ହେଇଥାନ୍ତା ତାପରେ ଦି ଜଣ rescue ରେ ଯାଉଛନ୍ତି ତାଙ୍କୁ ବି assault କରୁଛନ୍ତି
Preparation has to.
Then there is can be
Resolution.
evidence is
Intention
very
can be formed when
consistent.
there are discrepancies, Your Lordship, regarding the assault and the weapon of offense carried by the accused persons.
I was just thinking of convicting them 323. This thing.
Because the injuries are simple as per the doctor. That is why 323.
Sentence is 2 years, huh?
1 year.
1 year.
No, sentence is 6 months.
6 months. 96 incident.
Yeah, at least if the testimonies had been consistent, I would have asked for at least POI, but they stayed also within custody.
Custody, how much you say?
Custody means everyone, appellant number 1, 2, and 4 have stayed for 18 days. Appellant number 3 has surrendered on a later date. Appellant 5 and 6 have also surrendered on a later date. But the date is not, that portion of it's here is lost.
So what do you say, madam?
Are inconsistent, but there's a consistent statement of all that they have an assault. And the injury report is there, the doctor's statement is there, and the IU's statement is there. And there has been discovery of the weapon of offense from the
Inconsistency insofar as the PW 1, 2, 3.
PW1 is the main injury. He has been struck
So
on
you
the-
just point out those things.
In a
Give
note,
a
in a
note.
Not may
Also
resolve
give
it, I'll give it.
I'll just trigger the parties to file their respective written note of submission.
I may be permitted to take the LCR. I don't have.
Yes, soft copy of it they are submitted. Yes.
I'm great, sir.
20?
Please, madam.
Yes.
Yes, the matter was parted. My grounds herein was that I was charged under section 20B1 of the NDPS. And I've been sentenced to undergo a vigorous imprisonment for 2 years with a fine of 10,000. And in default to undergo 6 months.
Yes.
The case of the prosecution was that
In paragraph, in item number 20, I don't have the brief. Can I take the paperwork and assist you? Thursday, also paperwork.
You have given it.
Copy to my learned senior during that. It was parted last occasion.
That's the problem. Actually, somebody else was
Someone filed as Thursday ko rakh tale. Otherwise, I'll ask. I'll try to assist.
Why once partnered, second time partnered? Later, you give a copy.
Let him please. I'll answer that in my written.
No. At the time I'll hear it. Because 20 minutes in any case you have to see. He's pointing out non-compliance of.
Brass seal, there is also section 15 notice not
Brass
compliant.
seal,
with-
the same issue, 57.
There's a distinction.
57 not complied. And all these things he is bringing.
Less than commercial property also.
Just now I heard one matter.
Okay.
There she has relied upon the judgment of Justice 1975 OCR. 1975 OCR. Page number Justice Justice SK Mishra's SK South's judgment. You read that judgment. No, Justice Sahu's.
Manoj. The accused was Manoj Kumar.
Okay.
The petitioner name was Manoj Kumar Pani.
Manoj Kumar.
Incidental as good by being not so. All of the nothing else is
Read that judgment. Directly quoted.
I'm grateful, Manoj.
Yes.
The Lakshmi is posting it to Thursday.
Thursday, see. Yes, Mr. Samantrai.
No, I came here to watch somebody else, so that is over.
Section 24 is argued by Upasika Samant. Happens to be the daughter of the doctor.
Your daughter argued. She argued very well. She argued
I was just telling.
Delivery was outside when she finished, I came in.
No, she has done. That's what she cited that judgment.
She cited the judgment.
She only cited the judgment. She argued very well.
This is the 10th day in the court.
Oh,
Like father, like doctor.
really argued very well.
Thank you.